Hi guys, it's Kathy. I hope you're doing well. Sorry about that, but it was kind of if it was going to have to happen. My power just went out for just a second, which shut everything down. So if it was going to happen, right in between streams is I freaking deal. I mean, I got so lucky there. I don't know how I got so lucky, but I know it made this stream a little late, but I'll go a little late to make up for it because it's Sunday. So we can go as late as we want. There's no courts opening up. I would like I don't want to burn out on OJ, but I do want to get to the end of this trial. So I'm thinking about maybe, I'm already doing 2 hours now every day about. But when we get an opportunity like today to go a little longer, I think I might. If you don't want to stay around the whole time, that's fine. Like the first hour of this stream right here is going to be boring because it's the B team again. So just so you know, if you want to go take a nap or, do your laundry or whatever, you're probably not going to miss much the first hour of this stream. But the second hour of this stream is when the A team comes back and Darden takes the questions and gives them to the witnesses. And I don't know, he just is always so annoyed. He's always super annoyed. Mm, mm, mm. Oh, CJ, I can't. I record your presentation so I can see it. It's the green screen, and I don't even know why because, well, now you can see. Like this is gold. This camera either strips away all yellow, like this top does not look like this in real life. It's much darker. It just strips away all yellow like it did here, or it adds a whole bunch of yellow like it did the other day, and everybody was asking if I dyed my hair. Nope, that's just my camera doing its thing, which is fine. I don't care. It's, I don't know. I don't care. Let's just get to the B team. Let's get this going so we can get through this trial.
All right, back on the record in the Simpson matter. Defendant's again present with his second set of attorneys. People are ready with their third set of attorneys. All right, there was one other discovery issue. Just as to the other two issues, the court anticipates issuing a written ruling regarding the Kelly issue, regarding the scope of cross-examination issue. And we had a discovery issue also to take up. And I anticipate filing that Monday. Both, as to both.
And before we finish, we can have some limited presentations in chambers in camera. There were some, at certain points in the argument, we made reference to things that we want to present to the court in that fashion.
Yes.
Should I proceed with the tape?
All right, let's go as to the discovery issues, however, first.
Your Honor, we have a number of concerns about discovery abuses with respect to a letter we sent you. The first issue has to do with the tape, which is the one that I think is most pressing because we believe it requires a hearing. The second issue has to do with the failure to provide certain laboratory pages, lab note pages, which we've been getting out of order really from the commencement of these proceedings, but we received a whole series of pages dealing with the chronology of events starting in June through July from Mr. Matheson in particular that we think we should have had a long time ago, and they impacted on things as distant as the split hearings and certainly related to um, other important matters. A significant issue that we would address for the court and is the late disclosure of these sets printouts and the APIMS printouts, which we think is a discovery violation. There is a very significant issue that we've been given, what is it, Mr. Felicia, 200, how many pages? 283 pages with respect to shoe evidence, memorandums from the FBI of investigations that took place in August, interviews from all across the country, things that if we were to double track at this point in time with the limited resources available in the middle of trial is extremely difficult. We should have received all that material much earlier. There is an issue that will arise, I'm not sure it's so pressing for today, that a bindle of hair and fiber that was removed from the hat, the Bundy hat, in Albany by Dr. Lee, and was sent back and received at the SID laboratory, was subsequently lost. And Mr. Morton was unable to review that, and the prosecution has been unable to produce it. And we think that raises an Arizona versus Youngblood question, because that hat contained negroid hairs that were inconsistent with Mr. Simpson, which we think is potentially exculpatory evidence and would merit relief. With respect to the laboratory pages and the SETS documents, particularly the SETS documents, let me address that briefly. The problem there, Your Honor, is that we have been asking repeatedly from the very beginning of this case for all computerized records dealing with the chain of custody when these items were booked from the very beginning. We got property reports initially, then we got with dates that were all plainly inconsistent with the facts. Then we got a computerized printout a few months ago, maybe 5 or 6 months ago, that just indicated when things were officially booked. It took a long time to figure out what that meant. Apparently, it represented the date that things entered the APIMS system. I believe of the APIMS system as opposed to the SETS system. As the court recalls, the SETS system is the computerized tracking system within SID. The APIMS system is the computerized tracking system that I guess covers the Los Angeles Police Department. We finally received, with the courts, through the court's good offices and the efforts of Mr. Hodgman and Mr. Yokelson, I think about 2 weeks ago, or a week ago, really, a set of SETS papers for certain key items that we specified because we wanted to get what we could get. But when you look at those items, what it represents is every time a package is taken from one area of the laboratory to another, people have to hit their barcodes. And then it indicates whether something is in transit,
Counsel,
where it
I'm
went.
not familiar with what it is. What's
Okay.
the problem?
The problem is that in order to figure out what happened to each item of evidence, one has to go back through the voluminous testing records and try to figure out what was being tested or handled at a particular time, because what they're tracking are, they'll put like 7 or 8 bags or a whole bunch of envelopes into one big box. Then somebody in the serology lab may go in at various different occasions and test certain things or not. And in order to figure out who had access and where it went and how is an extraordinarily complicated task. This is not a system that is set up as many others are in a sensible fashion, where you can have one set of documents, computerized or otherwise, to figure out who had what item at what time, when it was taken out, when it was tested, et cetera. This is a nightmare to try to track through their evidence. Now, we should have had these documents a long time ago so we could figure out what we were dealing with and track these through. And it's late disclosure, we feel, and frankly, we haven't had any meaningful disclosure as far as the APIMS records are concerned. They just handed us these huge, incomprehensible sheets of documents. It seems to us merits an instruction to the jury that the prosecution has failed in its discovery obligations with respect to these chain of custody documents. They were not turned over in a timely fashion, and that the jury can consider that with respect to what judgments they can make about whether chain of custody was properly complied with. And we'll submit that request to you in writing, a formal request for an instruction. But the most pressing matter is this videotape, which I understand the court has viewed. We have been asking for this videotape for months because a long time ago we saw on a television news clip a picture of somebody taking this videotape at Rockingham. In viewing this videotape, as I'm sure the court notes, there's a time on it that indicates when, date and time. We've been informed by the prosecutors, well, disregard that date and time. It's not correct. They failed to change the camera when they shifted over to new time period. But whether it's the daylight savings, whether it was the time that it purports to be on the camera, or whether it's discounted or moved ahead by an hour by virtue of daylight savings time, there are conflicts that we can see with respect to which people are seen at different locations and the documentation that we have in terms of when different searches were conducted. Perhaps most important of all, what does this videotape represent? We want to take testimony at a hearing from the people who made it as to what they were taping, who directed them to do the taping, what they thought they were taping. Were they taping the Rockingham residence and all the various different rooms as it was before any searches were conducted? What searches had been conducted before this tape was taken? Is this some kind of an inventory tape, or was this a tape that was taken to memorialize where various different pieces of evidence were? That's a question that we should have been able to explore at the suppression hearings in terms of the legality of the searches. Be able to, this tape may suggest that searches were performed even before the search warrant issued. Or it goes to the nature in which the search was executed and the contentions about general search that were raised at that hearing. More importantly, for the upcoming collection witnesses, the location of various
Mr. Scheck,
items.
let me ask you this. Why do we need a hearing to do this? Why don't we just have the prosecution identify who the camera person was and make that person available for you to interview? I mean, why do I have to take up court time that I could otherwise use with the jury?
Well, we would like, Your Honor, well, first of all, I think that what we would want is that testimony under oath at this point, because we see contradictions. And we think serious issues. I'll give you a simple example, as I'm sure the court saw with great interest. At one point during the course of this videotape, the camera pans over the master bedroom and shows those straps that apparently were moved around at some point in time on the bed. And then just at the point where it's about to show the socks, a very critical piece of evidence in this case, and where they were at whatever time this tape was taken, the camera cuts all of a sudden and moves to a new position. We're very interested in why that happened. Also, the state of affairs in the bathroom and in other rooms, what was lying around, where it was, what knowledge these people have of that, that's something that we think should be taken under oath, that kind of testimony, so we can have that and use that on these issues.
Mr. Scheck, let me ask you this. Your letter to the court regarding this videotape was asking for sanctions, but you did not specify what sanctions you're seeking with regard to late disclosure of the tape.
That's precisely the point. We don't know until we make inquiry of how this tape was created, who was leading around the person that was doing the tape, what instructions they had, what the circumstances of this were. We won't know what precisely the dimensions of the prejudice are, whether this tape helps us in certain areas as much as we think it might, whether or not it's something that the prosecution should be precluded from using parts or any of it. We don't really know. In order to figure out the dimensions of the prejudice here, we have to have a hearing, because it's very hard for us to figure out even the time that this tape was taken, much less the impact it has on search questions and also on the upcoming testimony of the witnesses who sees things at Rockingham. That's our problem, and we want that under oath. I mean, I'd like to accommodate the court in terms of the jury time. That's why I was perhaps inappropriately pressing the court to consider this issue yesterday. But we're very serious about this. We think this is a very serious discovery violation. I can point out to the court that there's panning of that garage area and the door, objects near that door. That's something that the defense should have known when it was cross-examining Detective Lang about pictures of that. It's something that the defense should have been able to see in cross-examining Detective Van Adder and others in the trial. Mr. Kalin, about that whole generalia. What was the state of objects in that Rockingham address at a particular time is something that we were entitled to know at the suppression hearings and before this trial started. And we asked for this tape numerous times and it was suppressed. The circumstances of why it wasn't turned over, I think, are also extremely relevant in terms of what sanctions the court might want to impose. And I think we need to have testimony as far as that's concerned. So
So you're asking for a hearing at this point?
That's exactly right.
All right. Ms. Lewis, is this your issue?
Your Honor, actually, Mr. Goldberg is going to address the court first to set forth the law and talk about the other documentary items. I'm going to deal with the videotape, so if you don't mind, we can take it in reverse order.
All right, let's do the videotape first.
Oh, you do want to take the videotape first?
Yeah.
All right. Your Honor, I had a conversation with Detective Looper of the Los Angeles Police Department yesterday, who was the detective responsible for the execution of the search warrant on June 13th at the defendant's residence at Rockingham. I believe Detectives Van Adder and Lang were downtown with Mr. Simpson during that period of time, and that's why he was responsible for it. That videotape, as Your Honor has seen, I guess, several times now, depicts the premises in and about the house very briefly, and all of the valuable items, including the many trophies and plaques and awards and so forth within the house, as well as the furniture, paintings, other items of value, and was taken as part of LAPD's ongoing policy to videotape locations where search warrants are executed. It's a policy that came into implementation, I'm informed, because of the 39th and Dalton lawsuits, which happened a few years ago, several years ago now. So that the policy of the police department is to take a videotape for their own civil liability, administrative purposes, to make sure that they don't have claims against them later that they've stolen property or they've trashed premises. That was the whole reason why this particular tape was taken. The tape shows the same locations that are shown in photographs. The defense has had photographs of the interior of Rockingham for months and months. Those photographs show almost the identical things that are shown on the videotape, except the emphasis for the videotape is on the value of various items, because it was taken with that purpose in mind.
So are you indicating to the court that this was taken by some LAPD photographer or videographer?
Yes, it was taken by if the court recalls, there's a gentleman in a suit in there who I didn't recognize. He's apparently a supervisor from SID who was there, who came out with a, whatever you call somebody like that now, videographer, specifically for the purpose of capturing those things because of potential civil liability, which the Los Angeles Police Department occasionally experiences when it gets sued over matters having to do with the execution of search warrants. So that was an administrative tape taken for that reason, and it was a different, I'll just finish this sentence, I see you about to inquire, but it was taken by a different person than the person who went through and did the photos. And it's also evident that this was an administratively taken videotape, itself authenticating in that respect because of importance. It does not show the blood in the foyer, the blood in the driveway, the pathway.
There are two, it does look down at what appears to me to be two of the blood spots in the foyer.
Okay, I missed
Two of
that.
the
I'm sorry if it
right?
does.
And pauses it.
Yeah.
Well, I fast forward and rewound a little bit, so I didn't see that.
I watched it 4 times very carefully.
Well, I certainly trust Your Honor's perception then. But the point is that it did not go down the pathway. It was not meant to and did not record the scene as a crime scene. It did not record the most pertinent aspects of it.
Forgive me for interrupting you, Ms. Lewis, but the issue that I'm interested in is who took it, and why wasn't it turned over earlier than this week?
It was taken at Detective Looper's direction, as I mentioned. It was given to him the following day. He threw it in a drawer, knowing that it was going to be for administrative purposes. It didn't occur to him to seek to make it part of the discovery type of materials in the case.
All right, let me ask you one other question. During some of the news coverage of the search at the Rockingham residence, long before I had any involvement in this case, I did see some news coverage in the what I now recognize as the pool area, the table, the wrought iron table out by the pool area, of a person that I recognized as a district attorney photographer who was carrying a full-size VHS camcorder.
The DA photographer did videotape the June 28th search.
Okay, maybe perhaps that's what I saw.
I believe so, because I know this was an SID personnel on the 13th. And I believe the defense has had discovery on that June 28th
All right.
videotape. So what we're talking about here is something that was after Detective Looper threw it in his drawer. At some point after that, LAPD made available to the RHD an additional room to be set aside for this case alone. I was just going to give the court what happened to the tape after he threw it in his drawer.
Well, I'm just, Ms. Lewis, do you agree that perhaps the defense is entitled then to inquire of both Detective Looper and the videographer as to the facts and circumstances regarding both the creation of the tape and an explanation as to where it's been for the last 7 months?
I think that is a reasonable thing for them to do. We'll make Detective Looper available, assuming he's working tomorrow morning. It's Friday, I'm not sure, but we'll make him available tomorrow morning, and the same with the other person. They can speak to him. They're very forthright individuals. There's no reason to tie up this court's valuable time with a sequestered jury to have a hearing, some kind of a formal hearing on it. It's really not necessary, Your Honor. And the defense can easily satisfy their questions and their questioning with Detective Looper. And in fact, there's one aspect that Mr. Scheck didn't mention, but what we noticed about the videotape was a glove that shows up in the videotape more distinctly than it does in the photographs. And there's an explanation for that. They've not inquired about it, so I won't tell them. But Detective Looper certainly can tell them that. And I don't want to take up the court's time. I don't mean to be mysterious, but I've satisfied myself from looking at the videotape by asking Detective Looper certain questions about certain things I saw in there. And I think the defense can satisfy themselves more easily so probably by doing it informally with the detective and with the other person than in a formal court hearing.
All right. Mr. Scheck?
First of all, Your Honor, will we allowed to respond to the other items?
Yes, you will. Let me just finish the videotape first, and let's get that out of the way. Mr. Scheck, the only thing I'm interested in from you at this point is why do you feel it's necessary to have a hearing under oath at this point if the prosecution is willing to make these people available to you first to interview? Because my suggestion to you is that I'm going to direct the prosecution to make them available to you tomorrow if they're on duty and available. And after taking statements from them, if you feel a further hearing is necessary with testimony under oath, I'll accommodate you then. But I'd like to do it the easy way first rather than having to, I don't want to necessarily use up my court time.
I think that the only problem is that we can't be at two places at the same time. And I suspect that the next witness is Mr. Fung. And we would like to know what these people are going to say about the circumstances of the tape. And if we had even learned about it any time earlier, we could have taken up the court's suggestion. The problem is that this is directly relevant to the testimony we're about to hear.
All right, well, let's do this then.
I would note one other thing, Joe.
Sure.
I'm informed that employee at Mr. Simpson's residence testified at the 1538.5 hearing that she saw somebody there doing a videotape. So this was another reason that we've always maintained that there was such a tape, and I think they're on notice of it.
All right. Let's do this then. let's order Detective Looper and the videographer here tomorrow morning at 8:30.
One other person, too, Your Honor.
The most, I think, relevant person is the fellow in that interesting gray suit from SID.
With the badge hanging out
Yes,
of the.
yes.
Okay,
Who is?
you noticed that too.
I believe he's an SID supervisor. If these, again, if these people are working tomorrow, so.
Okay. How about if we have everybody here, those three persons involved here tomorrow morning at 8:30? Council be here at 8:30. We'll just have an informal interview. If you feel after inquiring of them that a formal hearing is necessary, I'll entertain it at that time. But I suspect, Mr. Goldberg, are you going to be handling the direct examination of Mr. Fung?
Yes, Your Honor.
And just out of curiosity, chronologically, where do you intend on starting your evidence collection saga?
It starts at Rockingham.
I was afraid of that. Okay. Well, I guess we need to resolve this issue first. All right, tomorrow morning at 8:30 with the three persons available.
Yes,
All right,
Your Honor.
and Miss Lewis, I give you leave to use the court phone right now, so let's make sure we get these people.
I'll do that in a minute.
All right, thank you, counsel. All right, Mr. Goldberg, as to the APIMS sets, etc.
Your Honor, before getting directly into the facts regarding this APIMS and sets issue and also the other issue raised by counsel, which relates to these new L numbers of the laboratory reports, I just wanted to discuss general principles of California discovery law as we understand them now in a post Proposition 115 environment, because I think that they will be helpful to the court in resolving not only these issues, but perhaps the issue about the videotape, as well as other discovery issues that are going to arise throughout these proceedings based upon the history of things that have gone on to date. First of all, the people's discovery obligation now, as I understand it, is limited to essentially two sources. Number one is the Constitution of the United States. We have to provide exculpatory materials, so-called Brady materials. And the second source is the Penal Code, 1054 of the California Penal Code. And therefore, in any discovery issue that is before a judge now in a post-Proposition 115 environment, there is essentially a two-stage analysis that the court must go through. One is to look at the issue of whether or not it is exculpatory within the meaning of Brady. And the second is then to go systematically through the Penal Code and mechanically apply what has been set down by the people of the state of California through the initiative process as the law of the state. Now, I'd like to address first this issue of what is exculpatory evidence and cite a couple cases to the court, which Your Honor is probably already familiar with in counsel. Don't worry, it's not the entire notebook here, but we'll do that later on this afternoon. But they do set forth a definition of exculpatory that I don't think we're really that familiar with here in California, because prior to Proposition 115, we basically did follow rules that were judicially created. And those discovery rules were essentially that we just had to turn over everything that we had in our case file unless it was somehow privileged. So the general rule is you give it over unless there's some specific reason why it is privileged. But that is not what the United States Constitution requires. And one case that discusses this is California versus Trombetta, the United States Supreme Court case that the court is familiar with at 104 Supreme Court Reporter, and I'm looking at page 2534. The court is probably familiar with this in the context of what we call in our state hitch motions, where a piece of evidence has been intentionally or negligently destroyed. But they also discuss discovery obligations, and they say that the definition of materiality for the purposes of determining what's discoverable is the same in the context of what we call a hitch motion as it is in the context of a Brady material. And what they said there is that whatever the duty the Constitution imposes on the states to preserve evidence, That duty must be limited to evidence that might be expected to play a significant role in the suspect's defense. And then they have a footnote, and in a footnote 8, they say, in our prosecutorial disclosure cases, we've imposed a similar requirement of materiality. And we have rejected the notion that a prosecutor has a constitutional duty to routinely deliver his entire file to the defense counsel. We know of no constitutional requirement that the prosecution make a complete and detailed accounting to the defense of all police investigatory work on a case. So the Constitution does not require us to turn everything over. It does not require us to empty out our files, as was done in a pre-Proposition 115 environment. So we know that materiality does not mean you empty out your case file and give everything that's not privileged to the defense. In order to decide what it does mean, we have to continue on with some of the cases. And next, I call to the court's attention another fairly well-known United States Supreme Court case, U.S. versus Augers, at 96 Supreme Court Reporter 2392, and I'm looking at page 2400. There, the United States Supreme Court says, the Court of Appeals appears to have assumed that the prosecutor has a constitutional obligation to disclose any information that might affect the jury's verdict. That statement of a constitutional standard of materiality approaches the sporting theory of justice, which the court expressly rejected in Brady. For a jury's appraisal of a case might be affected by an improper or trivial consideration, as well as by evidence giving a rise to legitimate doubt on the issue of guilt.
One of my favorite judicial passages.
It's one of my favorite too now, Your Honor. If everything that might influence a jury must be disclosed, the only way a prosecutor could discharge his constitutional duty would be to allow complete discovery of his files as a matter of routine practice. Whether or not procedural rules authorizing such broad discovery might be desirable, the Constitution surely does not demand that much. They went on the same page further on in another paragraph. The mere possibility that an item of undisclosed information might have helped the defense or might have affected the outcome of a trial does not establish materiality in the constitutional sense. So what we are essentially told in this case is we're talking about substantial evidence that might cause a reasonable objective fact finder to find a reasonable doubt. And that is the way it is also defined in California case law, where the court is probably familiar with the phrase substantial material evidence as being the sort of slogan
We are 30 minutes away from the A-team, guys. 30 minutes.
that we use to describe what's discoverable. And in People versus Gonzalez at 179 Cal. 3rd 566, they talk about this standard of substantial material evidence in terms of evidence that's expected to play a significant role in the defense. And they say in that case, citing Trombetta puts it this way: whatever duty the Constitution imposes on the states to preserve evidence, that duty must be limited to evidence that might be expected to play a significant role in the suspect's defense, to meet the standard of constitutional materiality. And then they continue on further down in that same paragraph. In our prosecutorial disclosure cases, we have imposed a similar requirement of materiality and have rejected the notion that the prosecutor has a constitutional duty to routinely deliver his entire file over to defense counsel. So we basically know, based upon the federal and California cases, that when we're talking about materiality, we're talking about substantial material evidence of the kind that's expected to play a significant role in the defendant's defense, such that it would cause a reasonable or might cause a reasonable finder of fact, in other words, an objective finder of fact, to find a reasonable doubt. Now, as I understand it, the defense in this case is fairly straightforward in some ways. As I understand it, the defense is that Detective Furman planted the glove and then perhaps broke into the vehicle, the Bronco, and wiped the vehicle with the glove. Now, if that is the defense, does the defense believe that it's reasonably possible that he took the glove from Bundy, drove it to Parker Center, booked it into evidence so that it went through APIMS, then drove back out to the location at Rockingham to plant it, and then wipe it throughout the Bronco. And that if they only had the APIMS material, they're going to find some evidence of this. It is very difficult when you apply the standard of constitutional materiality to figure out how they can make a legitimate argument that this APIMS and sets material falls within that definition. In order for the court to understand this, I'd just like to give you a little bit of background in terms of what these materials are.
Well, before you do that, Mr. Goldberg, isn't it correct, though, that the defense has already been given a set of each of these materials?
That's true.
So isn't the argument sort of moot? They've got it.
No,
The
because
question is how is it interpreted, or
Well,
whether or not there's any other way to.
they're asking us to reformat it. And see, this is one of the problems that we get into when, in my view, when we give them things that we are not required to do under the Constitution, that we're not required to do under the Penal Code. And I could turn to the Penal Code and also show how it doesn't come within any of the provisions of 1054. The problem that we get into is we think that we're being nice guys by jumping through all these hoops that they've set up for us. And every time that we've complied with these hoops, they always have a new hoop that they want us to go through. We thought, okay, we won't argue about the APIMS. We won't litigate it. We won't ask the court not to argue it. It doesn't come within the Constitution. It doesn't come within 1054. We'll be nice guys and we'll give it to them. We did the same thing with the sets material. We decided that what we were going to do on the APIMS material was, rather than trying to decide what they might want and what they might not want, is just give them everything. So it is incredibly voluminous. And it includes the kind of computer codes, and I don't know the correct terminology for it, the encrypted type stuff that's used in a computer to generate the thing that you can read. It's in English. Maybe Your Honor knows what I'm talking about, because I'm just not familiar with the correct computer
No,
terminology.
if you recall, I've seen the printout that we're talking
Yeah,
about.
that's right.
Okay.
So they have everything. What they're saying is that the materials that they have are sorted out chronologically. They're not sorted out by item number.
All right,
So-
Mr. Goldberg, let me just jump ahead of you for a moment. Your argument is going to be is that your only obligation, even assuming that these are material, meet the test of materiality, your only obligation is to turn it over, not to interpret it for them, not to make it easier for them to understand, that your only obligation is to turn it over. Whether or not they understand it is up to them. Whether or not it makes any intelligible sense to anybody is up to them. It's not your obligation to sort it, explain it, and help them digest it. That's your argument, correct?
That's essentially it, Your Honor. Yes, that's correct.
See, it's easy as a former prosecutor that I can sort of guess that that's where you're going.
Okay. Yes, that was where I was going, Your Honor.
I've heard that argument myself.
But in this case, it happens to be
I don't
correct.
mean to interrupt you, but sensing where you're going,
Okay.
I thought I'd sort of jump ahead.
No,
a few
I
steps.
appreciate that, Your Honor.
Okay.
And I don't know if the court wants me to continue, if you feel it would be helpful as to what exactly APIMS and sets are, because I think that it's been somewhat overbilled. They're not chain of custody type systems. What they do is they're something that would be used by someone who wanted to know where a piece of evidence was. So for instance, if I were looking for the socks, item 13, and I had no idea where it was, where to start, I could hopefully in APIMS find that it had been, if it were sent out of LAPD and no longer in their custody, that it was in the court's custody. I could find that. That's the kind of information I could get through APIMS. But that would be it. I could also find out when it went into LAPD's custody. So it's sort of an in-out type thing.
All right, and for the court reporter's benefit, why don't you give us what the acronyms APIMS and SETS stands for?
Yeah, I wish I knew, Your Honor. You know, I've been practicing law for almost 10 years as prosecutor, and I had never heard of these systems until this case. I don't know whether maybe Your Honor had. I know that you have more experience in the judicial system than I do. I've taken an informal poll and asked other prosecutors, and I don't think they've ever heard of it either. And I'd scarcely doubt that any defense attorneys prior to this case have heard of it. And that's why I have a lot of trouble with the idea that it is exculpatory material that would violate the defendant's due process rights if it wasn't turned over. I mean, everyone else has seemed to be able to litigate their cases and defend their clients without the benefit of this kind of material, except the defendant, Mr. Simpson.
Well, let me tell you what I foresee, though. I foresee cross-examination as to the chain of custody and integrity of the evidence during the testing process, and then asking the persons involved, primarily the criminalists from LAPD SID, to explain the chain of custody based upon these documents, which are probably unintelligible to the average human being.
Well, I think they're also, the APIMS document is also unintelligible to the criminalists because it isn't the system that they use in-house. And what I was trying to find out about the SET system, since as I said, Your Honor, I really had never heard of it or even knew that such a system existed. So when I was trying to learn a little bit about it and how it worked, I learned that many of the criminalists don't know exactly how SETS works either. They know what they do to it and how they barcode things in, but they don't have a lot of understanding in terms of what happens to the information once it's in the computer. It's the kind of information that it really only serves one purpose, and that's if you're a criminalist and you want to know where within the laboratory I can find this box at any given time, because remember, it goes to boxes, not item numbers. You can use the SET system to do that. So I don't know how they could cross-examine them really effectively about something that they have very little knowledge about. What they need to do is the same thing that we did in this case.
But I suspect their whole goal is just to show that there's no coherent inventory system.
Well, there is. And the coherent in
Well, I'm
inventory.
just saying that that's going
right.
to be their goal. Whether or not that's true or not is for them to decide.
Yeah. Well, what the defense has to do is what anyone would have to have done before the advent of computers. And evidently, this is reasonably new. I don't think that it's been around for 10 years or
Do you
anything
feel
like
comfortable,
that.
though, that I understand the prosecution position as to, now that you've turned over these computer printouts, that's the end of your obligation?
Okay. Thank you, Your Honor.
Okay.
I'll move on to the L numbers, if I might.
Sure.
This seems to be typical of many of the defense allegations of prosecutorial non-disclosures of information, in the sense that they don't give the court any specifics. They just say, we got a bunch of L numbers, new L numbers, and there's a discovery violation we want to sanction, without specifying what, if anything, is new, what's startling about these things, which one of these, if any, comes within the definition that we've just talked about in terms of exculpatory evidence or within the California Penal Code. Because again, we're turning over stuff that we really, in my view, in many instances, don't have any obligation to turn over. We've kind of taken the tact that is not required by the Constitution of emptying out our case files, and now they want to penalize us for doing this. What happened here, Your Honor, was with respect to a large number of these L numbers, Greg Matheson, who is one of the supervisors at the Scientific Investigations Division and also a witness in this case, was going through the materials that we've already turned over and recognized, as we had earlier on, that when L numbers were assigned initially, way back when, they were only assigned to the face page of a particular document, so that you might have a 12-page document with only the face page having L115, for example. And 116 would be a document that was 16 pages later, again being a face page. So in the interest of completeness and having some way of being able to prove, if we needed to, that the defense had a particular document, since they frequently come up to us and say, we never got this, and then we can go back to our records and prove that they did. What he did is he renumbered and reissued many of these pages that the defense already had. That reissuing was from page L579 to 715. So as to those items of these alleged 300 odd pages that the defense says or claims that they have that are new or previously unaccounted for, many of those I would assume fall into that category. As to the remainder of the items, according to what I have been able to determine, they are all relatively recent materials. And many of those materials dealt with records that were compiled, uh, itemizing the numbers before we sent them out to Albany for the defense inspection, itemizing them after they came back. There were notations as to the laboratory visit that occurred on Saturday. I believe that was the 3rd or the 4th of this month. There were many materials, many of these materials not falling with any of the provisions of the discovery law, which, as the court is familiar based upon our last discussions and the discussion of particularly Hines versus Superior Court, may include notes, but it would include notes of laboratory analysis, comparisons, observations, testing, and the like. And many of these things
15 more minutes. 15 more minutes of the B team, and then we can get back to the trial, guys. Hang in there.
were chronological references to events that took place that have nothing to do with testing or analysis of evidence, kinds of things that come within California case law that requires disclosure of certain notes under Proposition 115. So I think that the burden is really on the party that's making the allegation of discovery abuse to go through, to itemize the specific page numbers that they claim that they didn't have, and to try to articulate to the court what these are, why they're important, why there's been a discovery violation, so that the court has some basis upon which to make a decision on that issue. I just like briefly, I don't think the defense is asking for any relief on this right now, to mention the issue of the bindle of hair and fiber. I did not know anything about that issue until it was raised here, but what I can tell the court is that the procedure that the Los Angeles Police Department used is they photographed the evidence before it went out, and then photographed it after it came back. Of course, that's produced an enormous number of photographs, hundreds and hundreds of photographs, which the defense has. But that should be able to dispose of this kind of allegation. I'm not sure that the defense is asking for any form of relief on this at this time. Maybe they're just announcing it for whatever press value they feel it has. But I do believe that the court should summarily deny the defense claims of discovery abuses regarding the APIMS and set materials, and also the new L numbers.
All right, what about the comment regarding the 283 pages of shoe evidence and reports from the FBI?
That was something that Ms. Lewis also looked into.
So I'll stand up and talk about that with the court's permission.
All right.
Your Honor, these materials are almost exclusively repetitive copies of a form letter, essentially, that was sent from the FBI, I believe, to various shoe manufacturers around the country. So it's correspondence, basically, and it's other types of memos and correspondence from this expert who we will be calling. But it's correspondence. It's not materials which are discoverable, as Mr. Goldberg has just talked about in terms of what materials are discoverable. These were things.
Mr. Bodziak's
Yes.
materials?
Yes.
All right.
And these were, he basically cleaned out his files. Mr. Goldberg alluded to us cleaning out case files. It's a similar analogy. He, after finally completing his reports, and I don't want to represent they're totally complete, because they may not be. But in terms of completing the reports that have been done to date and the analyses that have been done to date, those were the priority. That's what he sought to finish on, and did. He got those out. And then he went far beyond what the defense even asked for in their recent letter, which requested materials from Mr. Bodziak, or Agent Bodziak. And that is correspondence and virtually everything he had in his files. So again, we turned over, as is my position as well, frankly, that we turned over materials which were not required under the discovery laws. And we have been especially forthright in this case from the beginning, and that was a decision made from the get-go to do that. But again, it's a similar situation where these are letters and correspondence and things that are not discoverable under the discovery laws that we turned over anyway. And so certainly we should not be sanctioned for turning over what we did not have to turn over. The defense should be grateful that they have received this information, and early, before the expert testified. Your Honor, I want to mention that I did talk to Detective Looper. He'll be here at 8:30 in the morning. He's spoken with Mr. Ford, the one who actually did the videotape. He'll be here. We've not yet reached the supervisor because he's out doing something work-wise, so we should certainly be able to reach him as well. And it also occurred to me, with back to the videotape for a moment, the blood on the carpeting would also be for liability purposes. That would be the reason why they would
Also the blood.
videotape that
Blood on the foyer.
on the foyer, whatever. It would be for liability purposes, so that they couldn't later claim that the, whatever material it is in the foyer or paint, I forget where this blood is, frankly, but, so that it wouldn't have been something
No,
that the
it's just
LAPD damaged.
I think the argument is going to be, though, that what time, when, who was there when it was collected, and if it's still there at 2:30 in the afternoon or 3:30, depending on what time.
I
stamp
have it
usually says.
through hearsay, because I didn't ask Detective Looper myself. I should have, that this was all done after the search warrant was executed, but we'll know that in the morning with certainty.
Okay. All right, Mr. Scheck, you want to tell me a little bit more about the bindle, the lost bindle?
Yeah. Uh, The Mr. Hodgman and Mr. Yokelson have been dealing with it. My understanding is that they actually have photographed the return of the bindle. So it was back here, and they, at this point in time, have lost it. So I think that's a pretty simple matter. With respect to the L notes, I think that Mr. Goldman's argument admits too much. First of all, the L notes were given to us out of order in the first place. In other words, we would get a crime scene checklist from Mr. Fung, and you'd find one page is L33 and the other one is 576. And that's the way we were receiving things in this case, and not great copies either. And you know, it is annoying because I wish I had a nickel for every time Ms. Clark got up and said everything was being turned over. But let's move on to the legal issue. United States versus Agers was overruled. United States versus Bagley is the law with respect to materiality. And the difference between Bagley and Agers on the issue of materiality is significant.
I don't know, Nan, but I think, and I could be way wrong, someone tell me if I'm way wrong, that the defense had some evidence and brought it back and then it was lost. I think, I don't know, I could be wrong, but I think that's what I think happened from what I heard.
Because in Bagley, the court points out that materiality should be determined from the point of view of what the defense wants to do with something, some suppressed evidence, what its theory of the case is, what it needed at a particular time. It's no secret that the chain of custody documents that we are specifically asking for all along has been an essential element of the defense, as the court from its comments revealed. There is no excuse under the United States Constitution to continually refrain from turning over material that tracks the chain of custody of these documents and is relevant. It doesn't strike me as a particularly persuasive argument that the criminalists at SID have no idea how the system works when it's designed to assist them in tracking documents and creating a chain of custody. That argument, again, admits more than I think Mr. Goldberg intended. And it's for that very reason that these documents were in chaos to turn this over so late so that it becomes a nightmare for the defense to try to figure out which item was tested at what particular point in time and who had access to it is sandbagging. We've been asking for this for a long time.
All right, Mr. Scheck, let me bring some closure to our discussion then. First of all, as to the laboratory notes, the L notes that you're discussing, the fact that these were turned over to you at this point recently, and this comment also goes to the FBI notes regarding the shoes. What I think you need to do is present to me something that indicates that these items are material, that they should have been turned over, and that there's some prejudice to you from having not gotten them recently. Because if they are as represented, they sound relatively innocuous.
No.
All right.
I mean, I tried to be specific. I'll tell you, I'll ask Mr. Glacier to address it. I'll put this in writing. But just so you know, I only addressed Mr. Matheson's chronology. Mr. Matheson testified as a witness in the split hearing. He, as you recall, had great difficulty remembering exactly what the discussions were on when evidence was going to be sent out for DNA testing and who did what and when.
So I understand
Well,
that, counsel.
he created a chronology. He was doing a step-by-step chronology that wasn't turned over when he testified and wasn't turned over subsequently. It was only turned over last week. Plainly material, and I'll lay that out for you.
All
Mr. Blazier can address, if you want now or if you want it in writing, the issue of the shoes.
All right, both as to the lab pages and as to the shoes, I want that in writing. As to the lost bindle, let's have Mr. Hodgman look into that.
Yes, I've already started that, Your Honor.
All right. As to the videotape, we will start tomorrow morning at 8:30. I expect all parties, interested parties, to be here at 8:30. As to the APIMS and sets matters, I think I agree with Mr. Goldberg's position that the obligation of the prosecution is to make whatever is available, which they have done, and they have no further obligation to interpret or simplify.
Our position is when they made it available. Too late. That's the point.
Well, now you raise that issue.
No, I said that at the beginning. The point is not, the APIMS records are unintelligible. Our point from the beginning is this. We have been asking from the beginning of this case for the chain of custody records, the computerized chain of custody
And they've
records.
given it to you. And if
Well, they
it's
gave it to us.
Mr. Scheck, if it's unintelligible, that sounds like a terrific thing to me, from your point of view, to cross-examine on.
No. The problem, particularly with the sets records, is that they refrained from giving it to us until I think about 3 weeks ago. Now that is wrong. That is a violation of their discovery obligations. It is plainly relevant to our defense.
Mr. Scheck, your arguments to me have never mentioned that you're complaining about it, that you just got it. You're complaining about what it
No.
says and how you interpret it. This is
No.
the first time you're telling me.
No,
Yes.
Your Honor.
Yes.
If,
Yes.
well, then I did not articulate it to you clearly enough. Let me be clear. My argument was it was turned over late, and the sets records, in conjunction with the other laboratory materials, require exhaustive cross-referencing. I think that's what I said. And by getting it late, we have been prejudiced because we still are trying to do that, and we shouldn't have that burden at this point in time. We should have had it months ago so we could further our investigation. That's the problem. To the court says, finally, we continue to be prejudiced by the prosecution's failure to produce in a timely fashion computerized records from SID and LAPD. That's the problem. Of course, it's an aggravating factor that they turned them over in the APIMS records.
So what remedy do you want?
I want an instruction. I want an instruction to the jury that the prosecution violated its discovery obligations by failing to turn over these chain of custody records in a timely fashion, and that they can consider that with respect to the credibility of the prosecution's witnesses on the issue of chain of custody.
All right, we'll stand in recess, 8:30.
One thing we need, very briefly, we still need to know the list of witnesses for the next 3 days, as per the court's initial order, especially now because there are different lawyers who are handling different witnesses and people are kind of.
All right, that's something that's supposed to be exchanged informally between the
Okay.
lawyers. All right.
Is the court's ruling on this, the APIMS and the consent material still stand?
Yes.
Can we just ask the court's question about scheduling issues?
All right.
In terms of tomorrow, I think there were still issues that they wanted to raise. The defense said about the boards that we intended to use. I wanted to know when that was going to be brought up.
Bring them here at 8:30.
Okay, so the court wants to do that before the witness is called.
Right. All right. That's the normal procedure.
That's why I wanted to make sure.
All right.
All right. Would like an opportunity to see the tape. May he stay here, use your equipment to view it?
We don't have it hooked up to the monitor right now. I excuse Ms. Fitzpatrick. She'll be here tomorrow morning. We'll show it to Mr. Simpson tomorrow morning at 8:30. 8:30 session is not open to the public. This is just informal discussions. We'll make that available. All right.
I doubt we're going to get that. We might get it. Let's see.
Counsel, Ms. Mr. Shapiro, Mr. Cochran, Mr. Neufeld, Mr. Douglas, people represented by Ms. Clark and Mr. Darden. The jury is not present.
Whoop,
Counsel, is there
we got
anything
it.
we need to take up before we ask the jury to join us?
Oh, we
Mr.
did not get it. No.
Your Honor, there's an even quicker manner. There's another attorney here who's representing Marguerite Simpson Thomas. There was a bench warrant issue and held until today, and it's my understanding, Mr. Darden, and that attorney whose name escapes me have agreed on
Mrs.
May 5th.
Hamburger. May 5,
May 5?
6th of the mile. All right, bench warrant, is that date agreeable to your calendar, counsel?
Yes, that'd be fine. Thank
All
you,
right,
Your
bench
Honor.
warrant will continue to be held, issued and held to that date.
Thank you.
Thank you, counsel.
Address the court, Your Honor.
Mr. Cochran, good morning.
Good morning, Your Honor. Your Honor,
Hey, I
yesterday,
knew-
there
I
was
knew that was
a
you.
witness
I
called
knew
by
it.
West Tech. And in the course of the proceedings, much was made of the security system at Mr. O.J. Simpson's home. And as the court knows, in this case, there are a number of people watching in. And we received a number of calls from people who were concerned, some of whom were even in state prison, about knowing about Mr. Simpson's security system. And I wanted to indicate
Do you guys mind if I play like 3 seconds of a short off over here on this side? You're just going to hear just something real quick and then you won't hear it again. You might not even notice. All right. But if you hear anything, just ignore it. It will only be I have to trim my short real quick.
for the record that due to this testimony regarding West Tech, Mr. Simpson's security system has now been totally changed, and there are armed guards on the property. I mention this because we always have concern for security. The court knows there are still occupants of that home, and I think it's important that everyone know that at his own expense, Mr. Simpson has done this, and he has a strong desire to not have his property invaded or intruded, and that his rights of privacy are protected, and he has paid out of his own pocket to have that entire system revamped and reconfigured as of last night. So I guess it's kind of a little burglars beware, if the court pleases.
All right. Thank you, counsel. All right, Mr. Darden, good morning. Are you ready to proceed with your next witness?
Yes, Your Honor.
All right, anything else we need to take up before we invite the jurors to join us? All right, Deputy Magnar, let's have the jurors, please. Gentlemen, record to reflect that we've been rejoined by all the members of our jury panel. Mr. Darden, you may call your next witness.
Thank you, Your Honor. Good morning, ladies and gentlemen.
It's Friday.
Yes, it is Friday. Thank you, Your Honor. The people called Charles Kale.
All right, Mr. Kale, would you come forward, please?
Sir, can you please raise your right hand? You do solemnly swear that the testimony you may give in the trial is not being before this court should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat for witness stand and state so your first and last name for the record.
My name is Charles Kale, C-A-L-E.
Good morning, sir. Mr. Kale, on June 12 and June 13, 1994, did you live in Brentwood?
Yes, sir, I did.
And during the month of June 1994, were you familiar with the defendant's, or rather the location of the defendant's home at 360 North Rockingham?
Yes, sir.
Had you been to that residence before?
I didn't buy it. I'd been on the property on holiday, something of that sort.
And are you acquainted with the defendant, O.J. Simpson?
We've seen each other in the neighborhood, and I know him from passing. And
Did you own a dog on June 12?
yes, sir, I did. Still do.
And directing your attention to the morning following the murders of Ron Goldman and Nicole Brown. And this will be Monday, June 13, 1994. On that date, at approximately 7 o'clock in the morning, were you on Rockingham?
Yes, sir, I was.
Were you in a car?
Yes, sir.
Were you alone?
No, I was having somebody drive with me to the airport to take my car back home.
Okay, so you were en route to the airport?
Correct.
And on that day, Monday, June 13 at 7 a.m. in the morning, did you drive down Rockingham?
Yes, sir.
And did you pass the defendant's residence at 360 North Rockingham?
Yes, sir.
Now, from which direction were you driving?
I was driving from north to south.
Okay, so you were just right there.
Definitely.
And as you approached the defendant's residence, did you have to pass through the intersection at Ashford?
Yes, sir.
And did you pass through that intersection?
Yes, sir.
Okay. Now, you've been at that intersection before at Rockingham and Ashford, is that right?
That's correct.
And I take it that you passed through the intersection on your way down to Sunset Boulevard?
That is correct. That's
And is there a path or a course that you usually take as you drive down to Sunset?
yes, sir. There is.
Do you usually pass through the intersection at Rockingham?
Usually, I would turn left if I were going to be going east on Sunset to go across to Cliffwood, and turn left at Cliffwood because there's a light, and you can't turn left onto Sunset from Rockingham if you're going down that way. There's no left turn sign.
Now, do I understand you to say that you usually turn left at Ashford?
Sorry, I had to
Yes.
open up my server for my kids.
Did you turn left at Ashford that Monday morning?
No, sir.
And why not?
Because I saw a black and white patrol car, police car, parked in the street just east of Rockingham on Ashford, between the corner and the gate in the entrance into Mr. Simpson's home on Ashford.
So you couldn't turn left?
Could have turned left and gone around, but it would have been, we had to go out of the way or off into the left lane.
Okay. And so did you continue then south on Rockingham?
Yes, sir, we did.
Did you pass the defendant's gate, the gate to his residence at 360 North Rockingham?
Yes, sir, I did.
And as you did so, did you notice a vehicle at all?
I did. I noticed the white Ford Bronco.
And where was the white Ford Bronco when you first saw it that Monday morning?
It was just to the north of the driveway, the Rockingham driveway, parked at kind of a strange angle with the rear out from the curb a little bit more than normal.
Did you pay particular attention to the Bronco?
Yes, sir. I was surprised to see it, and so I noticed it.
Okay. Why were you surprised to see the Bronco at that time?
Well, very seldom, if ever, had it been parked there. In fact, seldom, if ever, were any cars parked on the Rockingham side of the street as I went along from the past. And I noticed that. I noticed that it was parked at sort of a strange angle. I mean, you could tell it was out. The rear wheels were out a little bit. And also, I had not noticed it the prior evening.
You had not noticed the Bronco parked on Rockingham the prior evening?
That is correct.
Okay. Were you outside the prior evening?
Yes, sir.
Okay. This would be Monday, or rather Sunday night, June 12th.
Sunday evening, June 12th.
And why were you out Sunday evening, June 12th?
Well, I had taken my dog for a walk. I had been packing to get ready to go to the trip early the next morning, and I took the dog out for a short walk and had been walking on Rockingham. And when I was walking, I hadn't seen the Bronco.
Okay. Now, what time was it, if you recall, that you walked your dog Sunday evening?
About 9:30, 9:45 period.
And so during this time period of 9:30 to 9:45, you say you didn't see the Bronco on Rockingham?
Yes, sir. I did not see the Bronco on Rockingham.
Okay. Now, from which direction were you walking with your dog?
I was walking from north to south.
North to south on Rockingham.
That is correct. And then I returned and walked back south to north.
Did you ever pass the defendant's home at 360 North Rockingham? That is Sunday night?
No, sir, I did not.
Okay. How close did you come to the defendant's gate located on Rockingham Sunday night?
I would estimate about 60 yards probably.
Now you mentioned a moment ago that seldom, if ever, have you seen the Bronco parked on Rockingham.
That is correct.
Have you seen the Bronco parked at other locations?
Yes, sir, on Ashford on occasion.
Have one moment, Charlie.
I'm trying to remember. I think so. Yes.
I am missing Mr. Fairtlow at this moment in time.
Yes. Do you want to just proceed with the
Sure.
normal photographs?
I'm sorry?
Do you want to proceed with the normal photographs and just do it the old-fashioned way?
Yes, Your Honor. Mr. Kale,
Yes, sir.
the time you just indicated, you just told us that you were out at around 9:30 to 9:45 p.m. Sunday evening?
Yes, sir.
Okay. And
Should be right there. Certainly.
He should not be allowed to interrupt testimony because of this. That should not be allowed. If someone interrupted him while he was in his flow, not that Darden was in a flow, but he could have been.
Mr. Darden.
okay, you indicated that you were out around 9:30 to 9:45 p.m. Sunday night.
Yes, sir.
Okay. And how is it that you arrived at that time? That is the 9:30 to 9:45 p.m. time.
Well, I had come back earlier in the evening with one of my children, and we'd had dinner, and then I had started to pack for my trip the next morning, put my materials together to go on this trip. I know that I came back and went to bed shortly, about 10 o'clock or very shortly thereafter, because I had to get up early the next morning. And I know that when I got done with the packing and before I went to bed, I went out for a short walk, and that's the best estimation I can have is about between 9:30 and 9:45.
Sir, how certain are you that the Bronco was not parked near the gate at Rockingham that Sunday evening?
I'm very certain.
Perhaps Mr. Harris assist you with that?
I was just defending your flow, sir, and you just killed it yourself.
157. You don't just take it out and use it on the Elmo? All right, you see your monitor there, Mr. Kale?
Yes.
All right. Mr. Darden?
Looking at that photograph, Mr. Kell, can you indicate for us the point, or rather the closest point that you came to the defendant's gate on Rockingham?
Well, I just have to align myself here. It was in the area of, as you look at Rockingham, about a little farther than halfway up on the top to bottom line here. You see there's something that's sort of red, a vehicle of some sort that's red, and then, which would be on the east side of the street. And then if you come across diagonally, there's a car, looks like a car, a lighter colored car on the west side of the street.
Mr. Kell, we're going to place an arrow on the screen. If you will, please direct the arrow.
Well, okay, bring the arrow north on Rockingham, farther, and now go to the right there. So a line from that vehicle across to the left to the vehicle on the west side of Rockingham down here.
So you are on the opposite side of the street.
No, that line in there, the right, going all the way to the corner, right in there, that area.
Right there. Okay, can we come back and just place the arrow?
I would say that would be that's the general area, not all the way to the corner, but
Okay, can we come back and place
past the driveway on the right for the house on the north side of the street.
All right, so you're on the west side of the street, is that correct?
I was walking in the street, not just necessarily on the dog sort of goes back and forth, and there. At the time, there wasn't really very much traffic on Rockingham.
Now, when was the first time that you were interviewed by the police, Mr. Kell?
I would say it was in February, January, I think. I don't know the exact date, but it was in, I believe, in January of this year.
And did you contact the police?
They contacted me.
Okay. Now, you do live in the area, is that correct?
That is correct.
Okay. And you would prefer not to have your address published, I take it?
That is correct.
Now, when you walked down Rockingham that Sunday evening, were you able to see Ashford Street?
Well, excuse me. Bits and pieces of Ashford Street, because as you can see from the picture, there are a lot of trees, and if you walk down Rockingham, the trees really break up an unimpeded view of Ashford. You can see parts of Ashford.
Okay. Did you see the defendant's Ford Bronco parked on Ashford Street that Sunday night?
I don't recall seeing it on Ashford, no, sir.
Thank you, that's all.
Mr. Shapiro?
Before we begin, Cross, may we approach the reporter for a moment?
With the reporter?
Yes.
Not entirely correct, no.
Have you seen the report in this case?
I saw it very briefly this morning.
opportunity, well, let me just ask you. The report is a page and one paragraph?
Yes,
And was that report, when you had a chance to review it, accurate?
I took a very short, brief look at it. I thought it generally seemed accurate.
Do you know a person by the name of Jay Gardner?
I do,
Is that Jeff Gardner?
that is.
And who is that?
He's a friend.
What does he
He's
do?
also a neighbor in the Brentwood Park.
What does he do?
He's in the real estate business.
And did you call him about this Bronco?
We talked about the Bronco.
And did he tell you he would call the police, call a commander on your behalf?
He told me that he might be talking to somebody from the police.
And as a result of that, you got a call.
That is correct.
Nobody came to your house on June the 12th to ask you what you had observed. Isn't that correct?
On June the 12th,
Of 1994.
that's Sunday,
Yes.
Sunday night, no.
What about June 13th? Anybody come to your house to ask you what had happened?
I left for Canada on a flight at 8 o'clock in the morning.
Did the police come to your house to talk to your wife, family, or inquire whether anybody at your residence had any knowledge of events that took place at the Simpson residence?
Not that I'm aware
Did you talk to your wife?
of. Yes,
Did she ever tell you that she had been contacted by the police?
Oh, well, but he's already testified he's not aware of any contact.
And I know you don't want to give your residence location, and we will respect that. Can you tell us where you live in proximity to Mr. Simpson?
I live within, certainly within a quarter of a mile of Mr. Simpson, less than a quarter of a mile.
And up until the time that you called the police, well, that you called your friend and the police called you back, no one.
I didn't, excuse me, I didn't call him. I was talking with him.
You talked to your friend.
Yes.
And as a result of that, you were called by the Los Angeles Police Department. No one had come to take any statements from you, even though you live within a quarter of a mile of Mr. Simpson.
That is correct.
And what attempts did you make to report what you had observed to the police prior to January 25th of 1995?
I had made none.
What is your profession, sir?
I'm a self-employed private investor.
Do you have any legal background?
Yes, sir, I do.
What legal background do you have? Oh,
You can answer the question.
I have a law school graduate. I have practiced law in the state of California.
and is it your testimony that you would not know how to contact the police to report evidence that may be relevant to a murder case?
Sustain.
Did you tell, you talked to an officer by the name of Crotsley, Crotsley, on January the 24th. Isn't that correct?
That is correct.
And at that time, are you aware that he reported
Objection.
that you did?
Sustain.
Have you ever reported to the police that you didn't know how to contact them to give them information?
That never was an issue. The answer is no.
Let me show you a copy of the report that was prepared by Mr. Crotsley and see. Yeah, this is what you just showed him this morning. May we have that, please?
Counsel, I thought I directed you both to direct your comments to the court. All right,
Yes.
let's proceed.
Your Honor, may we approach, because apparently I do not have the complete reports.
He does not have the complete reports with him, Your Honor. There's a distinction.
All right, with the court report, please. Please.
May I approach the witness, Your Honor? Let me give you as much time as you need, sir, to read this report.
I've taken a look at it, Mr. Shapiro.
Have you had enough time to read it?
I've read it. Excuse me.
Do you see if there are any errors or omissions in that report?
Well, as I told you before, I don't think there was an issue of my not knowing who to contact in the first paragraph.
No, what is the error in the first paragraph?
You said it says in the sentence that Mr. Jay Gardner stated that a friend, Charlie Cale, had information regarding the Bronco but did not know who to contact. I don't know what Mr. Gardner stated, but so I don't know whether that's, I guess that's somebody else's comment.
Let me just ask you on that point, then we'll move on. Did you ever tell Mr. Gardner that you had information but you didn't know who to contact?
No, I don't think in that sense I did.
We ended Furman about a month ago, maybe. I mean, my concept of time is bad, but we did end him. He was like 2, 3, 4 people before. Well, before this guy, it would be like 7 people before this guy. I don't know. Again, you know what I need to do? I need to go back and rework my description so that we understand what's going each day. And it's a big ask, but I should really do it. It'll make it so much easier. But yeah, that's what I'm going to do.
We discussed the issue that was in the fourth paragraph, 1, 2, 3, 4, where some comment had come up on the news that said that there was a.
What's the objection? Overruled. You can finish your answer, Mr. Gale.
that had been reported in the news that someone was stating that the Bronco had been parked other than on Rockingham, and that it had been moved onto Rockingham by the police or by somebody, or that it had been changed its location. And Mr. Gardner and I were talking, and I said, I just had heard this, and he raised the question with me. And I said, that's not the case, because I saw the Bronco on Monday morning when I went to the airport, and I had taken a walk the night before, and it hadn't been there. So that's how the whole subject came. So you ask also if I knew how to go get a hold of anybody in June. In June, there was never an issue that I was aware of about where the Bronco was or was not parked.
I take it that you know that there was a preliminary hearing in this case.
Yes, sir.
And I take it you know that that was televised.
Yes, sir.
Did you see any part of it?
I don't think I saw more than 5 or 10 minutes of the whole hearing.
Did you?
On the news, perhaps, but I did not watch it.
And did you see any news reports of any issue regarding a Bronco?
I saw news reports that indicated that there was a Bronco parked there, and there was an issue of what was in it or on it or things of that sort.
So you knew as early as July of 1994 that the Bronco was at least an issue in this case, being a lawyer, did you not?
The Bronco was an issue. I don't know that it was an issue. I knew it was an element in the case.
And you're a reader of newspapers, are you not?
Yes.
You read about this case in the newspapers, did you not?
I read it in the newspapers, yes, sir.
And you were aware of something that's been referred to as a low-speed follow involving a Bronco?
I am.
Overruled at this point.
I'm familiar with that.
And so, as a lawyer, would it be fair to say that you could conclude that the Bronco was an issue in this case?
I don't practice law. But as someone who used to, I would say that the issue of the Bronco was in the case. However, there was nothing that I had seen or not seen about the Bronco that I thought was any issue until the latter part of January.
Being in close proximity to the Rockingham residence of Mr. Simpson, uh, did you find it unusual that no one contacted you, whether you heard any unusual noises on June the 13th?
No, sir. Where we are is far enough away and with trees that I don't think that it would have been on anybody's mind to necessarily ask if we heard strange noises where we were.
What about vehicles that might be going by?
My answer would be the same.
What if you were outside your residence walking your dog, as you sometimes do? Would that be something that you think the police might want to know?
Sustained.
Are you familiar with the vehicles of all your neighbors?
Not all of them.
Are you familiar with all the vehicles that were parked on Rockingham when you went to the airport that morning on June the 13th?
I am familiar with the two that I saw, one on Ashford, which was the black and white, and the other was the Bronco. And to my recollection, there weren't any others parked.
There were no other vehicles on Rockingham that
Not
day?
that I recall.
What about the night before? What vehicles were parked on Rockingham?
On Sunday night,
Yes.
I saw none.
Have you ever seen any other Broncos at Mr. Simpson's residence or in the area of, strike that, in the area of Rockingham and Ashford? Have you ever seen any other Broncos other than Mr. Simpson's Bronco?
I've seen other Broncos, yes, sir.
And you've seen them parked in many different locations, have you not?
Seen them parked on Ashford.
Have you seen Mr. Cowlings in the area of Mr. Simpson's residence?
Yes, sir, I have.
And have you seen his Bronco parked on Rockingham?
Not that I recall.
Is there
I've seen his Bronco parked on Ashford, I know.
Is there something in particular about noting where a Bronco is parked 8 months ago that is important to you?
I don't really quite understand the question, Mr. Shapiro.
Have you watched any part of this case on television, any part of this trial?
Very little,
So you've watched some of it.
very little.
What have you watched?
I've seen news clips from the news when I watch the regular news. That's really about all.
Have you seen any witnesses testify in this case?
I've seen saw Detective Furman briefly, and I don't know the detective, I don't even know his name, was here in the gentleman sitting behind counsel. I saw
Indicating Detective Lang.
and I probably saw 2 or 3 minutes in total of Ms. Lopez.
And you were aware that all 3 of those people gave testimony regarding the Bronco, are you not?
Sustained. Be stricken, jurors to disregard.
I'm sorry, are you aware that Detective Furman gave information regarding the Bronco?
I really don't know what information Detective Furman gave about the Bronco, if he did.
About Detective Van Adder?
I did not see Detective Van Adder at all, even on the news that I can recall, so I don't know what he talked about.
What about Detective Lang?
I don't remember anything that he talked about. I just remember seeing him.
Can you tell one Bronco from another?
If you have, that's a question I don't know how to answer, Mr. Shapiro.
Yes or no?
I don't think that's a question that's susceptible to answering yes or no. If you have 2 identical Broncos, I couldn't tell which was which. I can tell you that I recognized a Bronco when I saw it.
Did you recognize it as Mr. Simpson's Bronco, or did you recognize it as a white Bronco?
I recognized it as a white Bronco.
And the closest you got to the Simpson residence is where you've put this reddish orange marker on the Elmo?
That's my best recollection. Yes, sir. It was in that general area.
And it could have been before 9:30 that you were walking your dog, isn't that correct?
Don't think it was.
But you're not sure.
I'm very sure.
You're
that-
very sure.
That
Do you
it was
walk
in the
your dog-
9:30 to
wait,
9:45 timeframe. That's the best estimate I can give you, sir.
Well, you just used the term the best estimate and you're very sure.
Yes. I don't think those are inconsistent.
So you would, in your definition, your best estimate is being very sure of something.
When you have a period of time within certain parameters, I'm very sure of my estimate, that it's in that range of time.
Could it have been 9:25?
I don't think it was. Is it possible? I guess it's possible. I don't think so, though.
Do you walk your dog at a regular time every evening?
No, sir, I do not.
Do you walk your dog every evening?
No, sir, I do not.
Do you walk your dog every day?
No, sir. I walk the dog sporadically on occasion.
Did you walk, when was the last time you walked your dog before the evening that you've testified to?
I don't have a specific date. I walked it within that week, I know.
What cars did you see on Rockingham when you walked your dog within that week?
I don't remember that.
How far were the rear wheels of the Bronco, I think your words were jutting out into the roadway? Have you heard that? Let me ask you this first. Have you heard that term used in this case by anyone else?
No, sir, I have not.
Have you read that term in any of the newspaper articles?
No, sir, I have not.
Have you seen it on any newspaper clippings?
No.
Any news clippings?
No, sir.
How far was the rear end jutting out?
I would say, again, I was driving by in the car, and I was, say, appeared to me to be 18 inches from the curb, with the nose, the front right wheel closer to the curb.
Now, you're aware that there is a concrete gutter area and then asphalt on the street, is that correct?
Yes, sir.
How wide is the concrete gutter area?
I don't know.
Could you
6,
get-
8 inches, I would assume.
So the tires then were more than 10 inches to a foot, the rear tires on the asphalt?
I really can't say. Again, we were driving by. I looked and I saw that the car was out at an angle which wasn't parallel to the curb. I didn't stop and look.
You just gave testimony that was 18 inches away from the curb.
I said that was my estimate. I believed it looked like it was about 18 inches from the curb. The nose wheels were close against the curb and the rear wheels were out from it.
And if the concrete area is 6 to 8 inches, then by simple, isn't that what you testified
I guess
to?
when you say concrete, you mean the curb comes down onto the street?
Is there a concrete gutter area on Rockingham?
There's a curb, and then the curb necessarily makes a gutter when it, I guess you'd say, when it comes to the street.
And my question to you is, how wide is the gutter?
Oh, well, do you understand the question?
I really don't, Your Honor.
Just describe the curb, the gutter area, and the asphalt on Rockingham adjacent to the Simpson property.
I believe that there is a concrete curb. The curb goes down to the street and then out some inches, which I think is what I said, 6 to 8 inches from the vertical. And at that point, the asphalt starts.
So your testimony then is if the car is 18 inches out onto the asphalt,
18 inches from the vertical curb.
are you from the vertical curb?
Yes, sir.
So that it would be on about 10 inches of asphalt.
Those numbers, yes, sir. I'm not saying that Well, if you take the numbers, that would appear to be correct.
And those are the numbers you've given us.
That's the numbers I've given.
Were you driving the car on the way to the airport?
No, sir, I was not.
But you were on the passenger side.
That is correct.
Did you see any other vehicles in the area of Rockingham and Ashford other than the the one black and white police vehicle and the white Bronco?
I have no recollection of seeing any others. It really wasn't an issue. I mean, we were going to the airport. I saw the police. I said, let's go straight. I saw the Bronco, and we continued.
You saw the police or you saw a police vehicle?
The police vehicle, the black and white.
Did you see any policemen?
No, sir, I did not.
Did you see anyone guarding the Bronco at 7 o'clock in the morning?
No, sir, I did not.
Did you see the Bronco cordoned off in any way to look like it was being secured?
No, sir, I did not.
Did you see the house cordoned off as if it was a crime scene area?
I don't have any recollection of that.
With the court's permission, put exhibit 1037 on the Yamaha. I want to direct your attention to the photograph that's being displayed.
Yes, sir.
Do you recognize that vehicle?
That appears to be the white Bronco parked on Rockingham.
Do you know who owns that vehicle?
I believe that that's Mr. Simpson's vehicle, but it's, I'm not positive of that. I haven't seen the registration. It's the white Bronco.
And what is it about that vehicle that leads you to believe that it's Mr. Simpson's from this photograph?
Well, it appears that that's Rockingham, and the car is parked with the rear wheels out. That's all I can say.
Well, how does that identify it as being Mr. Simpson's Bronco?
Well, that's the white Bronco, whatever the white Bronco was that I saw.
And would you say that the wheels are in the same position you saw as you were driving by as a passenger on the way to the airport?
That looks correct.
And you would say that the back tire is 10 inches onto the asphalt?
Well, looks like the outside part of the tire is a couple of inches on the asphalt, and the front tire is closer in.
And you describe that as jutting out and being very unusual.
I think I said it jutted out.
Would you describe that as being unusual?
I don't think that's a paragon of parallel parking, but is it parked illegally? I don't know. The front wheels are in and the back wheels are out farther. That's what I saw when I was on the other side.
And how much time elapsed when you passed by that vehicle? At the time you were on the way to the airport?
We slowed down when we came to Ashford, thinking we would turn onto Ashford. I said, let's go straight. So we passed it accelerating from 5 or 10 miles an hour to 20 miles an hour, 25 miles an hour. We just drove by in passing. Probably saw it a couple of seconds.
Who was driving you?
A young man by the name of Joel.
How do you spell that?
Joel.
And did you mention anything to this individual about what
This is a picture of how bad it was parked, which is lovely, which is not, I mean, is it perfect? No. But this is in no way, shape, or form parked in a way that would cause me to react in any way, shape, or form. I mean, this is just so stupid. This is not jutted out into the street. This is not, this is close enough to the curb, even though it's out a little bit further than the front is in too far. That's the back is not out too far. It's just not out too far. Is the front over a little bit? Barely, like just a little bit, just like a tiny bit of one tire, for crying out loud. So I have no idea why that this Bronco parked this way would cause a police officer to investigate it and find blood. That never made sense. I mean, I would be up shit creek if this was a problem. I mean, seriously. Gosh. Okay. I mean, there's other pictures I'll try to find, but at least you see that one.
Walking your dog the night before.
Well, not about walking the dog. I mentioned to him, I said, that's strange. The car is parked there and it wasn't last night.
When was the last time you talked to this man?
Probably yesterday.
He works for you?
He does on occasion, yes.
In what capacity?
He drives.
Your chauffeur?
I wouldn't have it raise it to that dignity, in the sense that he's not there all the time, but he just drives and does errands.
Are you aware that Mr. Cowlings has a key to the Rockingham gate?
Sustained.
Have you ever seen anybody enter the Simpson residence from the Rockingham gate?
I don't know that I ever have seen anybody enter from the Rockingham gate. I've seen people come out from the Rockingham gate. I don't recall that I have or have not.
Have you ever seen Mr. Cowlings enter from the Rockingham gate?
No,
Have you ever seen Miss Barbieri enter from the Rockingham gate?
I have not.
Do you know who she is?
I only know by name and reputation. I don't know her personally.
By name and reputation?
That she was a friend of Mr. Simpson's.
How do you know that?
I've heard that.
Where?
People have talked about it.
Certainly.
Paula Barbieri has a white Bronco.
No, sir, I don't know anything about Miss Barbieri other than what I just said.
You are aware that Mr. Cowlings has a white Bronco?
Yes, sir, I am.
And do you know that the only way that an outsider can gain entrance to the Rockingham property, to Mr. Simpson's residence, is through the Rockingham gate?
Excuse me? Would you?
Sustained.
Is there anything in
There it is.
particular about
It's
the
not
Simpson
bad.
residence that causes you to focus on it?
Well, it has a.
Overruled. You can answer the question.
It's not even a little bad.
Yes. Mr. Simpson is a celebrity. Certainly I think one of the most well-known people in the neighborhood. Also, it's on the corner where you either going south or, either going west or east on Sunset. If you're going to go to Sunset, you go by Mr. Simpson's house. It's distinctive. It's Christmas lighted brightly. I mean, I think it's a focal point.
And you said it was lighted brightly. So you can, by walking by, see that house and
No,
focus in?
I said at Christmas.
Oh, at Christmas.
Yes,
What about normally? Isn't there a halogen light on the corner of Ashford and Rockingham? Street lamp?
there's a street lamp at the corner of, yes, sir.
And doesn't that illuminate the front of the Simpson property?
Not the light I know there are lights on the property.
Oh, well, he can answer.
There are lights on the property. There's a blue, if that's a halogen light, and there's some other lights on
The
the.
property is very well lit at night, is it not?
Beg, want to rephrase the question?
Are you aware of the lighting on the property at night?
What you can see from the street.
And what can you see from the street?
There's one of the trees I know is uplit on Ashford with I think, I'm not sure if halogen is the blue light, with a bluish green light, as I recall. There are some lights that you can see around again, that there is some light around the driveway. And that's really all I can recall, that there's some lights in the back by the pool area sometimes that you see.
On the night before you left for the airport, did you see a limousine in the area of Ashford and Rockingham?
No, sir, I did not.
If there was a limousine parked outside the Rockingham gate at about 9:30, would you have been able to see it?
Or will,
I believe so.
And if there was a limousine driving up Rockingham to Ashford, would you have been able to see it?
or will, you can answer the question.
I believe if it had had its headlights on, I would have.
And if there was a limousine parked across the street from Mr. Simpson's residence on Ashford at 9:25 to 9:35, would you have been able to see it?
Sustained. That's the point of that question.
Regarding a limousine, did you ever see any limousine parked along Ashford that night while you were walking your dog?
Overruled.
I did not see a limousine parked on Ashford when I was walking the dog.
And you're a pretty meticulous person. You're very, very observant of things, are you not?
I don't know how to answer that. I don't know. My wife doesn't think I'm as meticulous, perhaps.
Join the club.
I try to be observant when I'm out walking at night.
Did you see any people walking in the neighborhood when you were out at 9:30?
No, sir, not that I recall at that time.
You recall seeing a limousine driver outside of Ashford smoking a cigarette?
Overruled.
No, sir.
Hold on. The jury's heard the testimony of both witnesses. They know that they can put the two testimonies together. All right.
About a Bentley. Did you see any Bentley at the Rockingham property at 9:35?
No, sir. I didn't look into the property.
Pardon?
I didn't look in the gate.
Did you see any small foreign vehicle on Ashford at all that entire evening when you were out?
I did not see any on Ashford, no, sir.
You didn't see any car. Did you see a Nissan Z on Ashford?
I think I said before, I don't recall seeing any cars on Ashford.
When you reviewed this report that I've shown you, and you see where it indicates that,
Objection.
did you tell the police officer?
Calls for hearsay, Your Honor.
Sustained.
And I would ask Mr. Shapiro to the record, give me an opportunity to see what he intends to read to the record.
Counsel.
Thank you. Mr. Kale,
Yes, sir.
did you previously tell a police officer who took a report from you that you went to bed at 10:30 that evening?
Objection, that mistakes the report, Your Honor.
I told
Overruled.
the police officer that I recall getting home to try to get in bed sometime after 10, between 10 and 10:30. It says here that I said 10:30 because I wanted to be in bed early because I had to get up early the next morning. I don't know whether I told him I was in bed at 10:30 or 10:15 or 10:10.
Do you know what time you were in bed?
I know I was in bed by 10:30. I think I was probably in bed earlier than that, actually.
Are you as sure of the time you were in bed as sure of the time you were walking your dog?
I'm sure that I was in bed between 10:15 and 10:30. I think I may well have been in bed before 10:15, but I wasn't in bed at 10.
You would agree that it's very difficult to be precise on times unless you're looking at a clock for a specific reference. Isn't that true?
I think that that is true.
Thank you. I just have a moment.
Ten 10:30 a.m. is early for bed for me. I don't even know either. I don't have no idea what time it was. It was it was in between my short that I put out, no, my video that I put out and my short that I put out, whatever time that was. I know I woke up around 1 because that's when I got that other short video out and more content for today's stream. 1 a.m. is when I woke up.
Putting up people's 157.
I plan on going for a bit longer today, unless you guys are like done. If you guys are like done, I'm done. That's enough OJ for one day. I've been here for 2 hours. I have to pee. Let me go. Then I'll stop. Um, but if I can make it to for 56 more minutes for one more hour, I'm going to. Well, actually, I'll just see if my viewers drop to 0, then I'll stop. Mods, you absolutely don't need to stay. Go do something.
Yes.
157A. Yes. 157A. Madam Reporter. 157A, this exhibit.
Let's see if we can get her up on the Elmo. Can we put that on the Elmo, Your Honor?
It appears to be.
On the big screen here? There we go. Mr. Kale, how far is your house from the red line you've drawn?
You can tell us in distance.
14 washing machines. You know how Americans measure. 16 bathtubs. Tell them in kilometers and watch them
I'm
all
interested
freak.
in probably is how long it would take to walk from his yard, walking his dog to that location,
That's precisely the point, Your Honor.
knowing the particular idiosyncrasies of this particular dog.
Walk with the dog, it would take me 3 or 4 minutes
What's the distance?
depending upon what the dog was doing.
What's the distance?
I could, without the dog, I could walk it in probably 2 minutes.
What is the distance in, you gave us before a distance of a quarter of a mile
Well,
from your residence to the Simpson residence. What's the distance from your residence to the red line?
Well, as I said before, I live within a quarter of a mile.
30
It's less than a
seconds,
quarter of a mile.
56.
I mean, I don't know, Your Honor, do you want me to tell them in numbers of specific yards? And
No, I think walking it in 2 minutes is the material issue.
I mean, it's less, with the dog, it could be, again,
Would you trace the route that you walked your dog and directing the arrow on the Elmo? Please.
That's not particularly relevant at this point. The route as to how he got there. The issue is how far down Rockingham did he get? How close to the Rockingham residence in the Bronco did he get? That's the issue.
Would you indicate, thank you, Your Honor, on the Elmo, where you believe, where the Bronco was when you saw it on the 13th?
Is this the full view, Mr. Harris?
again, it's difficult because of the definition and the angle here, but the closest I would say, and again, I don't know where the driveway comes out, but you see on Rockingham, just above the border of the photograph, there are two, looks like two vehicles, sort of whitish vehicles. And it would be, again, I'm having a hard time just getting the exact reference to where the Rockingham driveway would be, but it would appear to me that it would be the southernmost of those two vehicles. That's the general location.
And how far in distance is that location from the distance that you walked your dog closest to the Simpson residence?
The closest I got was in the general area of that red line. And as I said before, I thought it was probably about 60 yards.
Have you ever measured that off?
No, sir, I have not.
So if you're looking at a football field, that would be a little further than most kickers can kick for some points. Not Adam Vinatieri. We're not talking about him. So just look at how much your favorite kicker kicks a ball and then add like 15 yards. And that's 60 yards. Now do we understand?
Is that just an estimate, just a guess or an estimate?
That would be my estimate.
So we're precise. If you could direct Mr. Harris to circling the vehicle where you believe the Bronco was.
Well, subject to my problem of not being able to see where the line of the driveway is, and it was parked immediately, to the north of the driveway, it appears to me, with that little caveat or exception, that it's the location is the lower of I see this little mark is marking. I would come down a little bit, and now that to the right of that, it's now up onto that vehicle. That vehicle, I mean, I can't really even tell if that's a vehicle or a truck, or I don't know what it is, but it looks like there's something parked there. And that would be where I believe the Bronco was parked the next morning.
Well, is this a correct indication of where you're trying to establish
Yeah,
that
I'm
location?
trying to, yes, sir. And I'm assuming that that is to the north of the driveway, the Rockingham driveway. I can't see the Rockingham driveway on the photo.
Did you receive a call from a member of my office, Mr. Pat McKenna?
I received a call from somebody at your office whose name McKenna sounds correct. I didn't take the name down, or didn't get
How many did you talk to him?
I talked to him. Yes, sir, I did.
On how many occasions?
I talked to him once, just very briefly.
What date was that?
That was the day before yesterday, I believe.
You sure of that?
believe so.
I'm just asking you, are you sure of that?
I,
Or are you just guessing?
no, today is Friday. He called me Wednesday afternoon.
And where were you when he called you?
I was at my office.
And did he ask to have an opportunity to speak to you about your observations?
He said that he worked for the defense team and was an investigator, and he had seen my name from the district attorney's list, and he hoped to have a chance to talk to me at some point. I told him that I was leaving then. I didn't feel very well, and that we could talk later.
You can talk later?
We did not talk later.
But you told him you
I
could
said
talk
we
later.
could, let's call back later.
And did you tell him when to call back later?
You know, I said I'm leaving now. I said let's talk like maybe next week.
Next week,
I think that was what I said to him.
after your testimony.
I did not know at the time that I was going to be testifying then.
Did you have his number?
No, sir, I did not.
Did you have my number?
I received your number last night.
Did you receive my home number?
Yes, sir.
And did you get a request that I would like to talk to you before you testified?
Yes, I did.
Did you call me back?
No, I did
Thank you.
not.
Nothing further.
Mr. Darden?
Kelly, is there some reason that you did not call Mr. Shapiro back last night?
Well, I received a call from a mutual friend sometime after 8 o'clock in the evening. I had really not been feeling well, as I had explained. And I did not know that I was going to be necessarily testifying today. And I didn't really think at 8:15 I needed to call him back. I didn't feel up to it.
And did you attempt to explain this to Mr. Shapiro this morning?
Yes, sir, I did.
In fact, we dragged you out of your sick bed today, didn't we?
Yeah. Yes.
You've testified that you were out on Rockingham around 9:30 and 9:45 p.m. Sunday night. Is that correct?
Yes, sir.
And so if a limousine had parked on Rockingham at 10:22 p.m. Sunday night, you wouldn't have seen that limousine, would you?
I was in bed. Don't know that I was asleep, but I was in bed.
Okay. And if the limo was at Rockingham at 10:39, you would not have seen it?
Same answer.
And you did give a statement to the police
Julie!
in late January,
Julie?
is that correct?
Yes, sir, I did.
And when Mr. McKenna, the defense investigator, contacted you, it was just this past Wednesday, is that right?
It was Wednesday in the latter part of the afternoon.
And that will be March 29?
Yes, sir.
Okay. And does the statement there in front of you, the one Mr. Shapiro gave you, indicate the date of your interview?
January 25, 1995.
So you spoke to the police on January 25, and Mr. McKenna contacted you on March 29.
Yes, sir.
Have one moment.
Certainly.
Come on, Darden, let's go. Let's go. I want to speak to a manager.
When you spoke to the police in January, did you give them the approximate time in which you were out walking the dog?
Yes, sir.
Did you tell them about the Bronco not being there?
Yes, sir.
Thank you, sir.
Mr. Shapiro?
When you were walking your dog, sir, did you see a Bentley automobile driving up Rockingham?
No, sir.
If a Bentley had been driving up between 9:30 and 9:45, were you in a position to see it?
It had its headlights on and was up that far to the corner. I would have been, yes, sir.
You're familiar with what a Bentley looks like?
Yes, sir.
Have you seen a Bentley vehicle at Mr. Simpson's residence?
Yes, sir.
Did you see that vehicle driving up between 9:30 and 9:45?
No, sir.
When were you told by any member of the district attorney's office or prosecution that you would be required to come to court today?
I was asked yesterday to come this morning to meet with Mr. Darden.
What ti-
I did not know that I was going to testify till I got here.
What time were you asked yesterday to come to court?
It was in the morning.
Had you received a subpoena to come to court?
Yes, sir.
And what is a subpoena?
It's a order of the court to appear,
For what purpose?
to testify.
As a witness?
Yes.
So when you got my inquiry to kindly call me back at 8:30, you knew you were going to be a witness today in this courtroom, did you not?
No, I did not.
You didn't have the subpoena.
I had been subpoenaed some weeks ago. I had been told that I was on call, that they didn't know whether they would use me, and that they wanted to have me meet with Mr. Darden, at which time there would be discussion or a decision made by Mr. Darden whether, when, and if I would testify.
No,
I met
you-
with Mr. Darden this morning.
You knew court was in session today, did you not?
I think so.
And you know Mr. Darden's one of the lawyers in this case,
Yes, sir.
and you know he's in court every single day.
I guess he is in court every day. Yes, sir.
And that your wife was told by, at my request, that you were subpoenaed as a witness by the district attorney for today? She told you that, didn't she?
I'm sorry, I didn't follow the question.
Didn't your wife tell you yesterday that you were going to be a witness in this case today?
No, I don't think my wife told me that.
Well, sir, as a lawyer, having received a subpoena, being put on call, being notified that you were to come to court and to see Mr. Darden, who has been in court every day since this case has begun, did you come to the conclusion that you were going to be a witness in this case, sir?
I thought there was a chance that I would be. I did not know that I would be a
I
witness.
guess I'm going to have to marry him or at least date him now. I don't know if he can be nuts because I wasn't attracted. So that means he must be seen a little bit.
Today.
And knowing that, you still did not return my phone call, did you?
I received your phone call, sir, at 8:15. I had been in bed much of the day, and I thought at that point that there really wasn't incumbent upon me to call you back.
And I also
I did make myself available here to you this morning.
and I also told you this morning that if you were not feeling well, that we would have no objection to recessing this case and you coming back when you were feeling fine. Isn't that correct?
That is correct.
And at that point in time, you said you'd like to talk to Mr. Darden, didn't you?
Yes.
And I was never given the opportunity to talk to you until you took the witness stand. Isn't that correct?
Objection, Your Honor.
I don't.
Objection.
Stay. For Fred's question.
Did you allow me to talk to you after that conversation?
Mr. Shapiro, I was sitting there. I expected that you would come back. You didn't. I talked with Mr. Darden about whether or not he was going to put me on now or whether I should come back later.
And what did Mr. Darden tell you?
He said he wanted to put me on now.
And did you tell him that you were feeling ill and that you shouldn't be put on?
I told him I didn't feel particularly well.
Did you tell him you'd rather not testify today? You'd rather take Mr. Shapiro's suggestion and come back when you were feeling better?
I'd rather not testify at all.
Mr. Darden, anything else?
Mr. Kell. I have nothing further, sir.
Mr. Kale, thank you very much, sir. You're excused.
Thank you.
All right, let me see counsel without the court reporter, please. What will be presented to you during that phase of the trial, since we're going to be shifting gears here. I anticipate that that will take me a couple hours to do, so I'm going to cut you loose for the morning session. Please remember my admonitions to you. Do not discuss the case amongst yourselves, form any opinions about the case, don't conduct any deliberations, and do not allow anybody to communicate with you with regard to the case, and I'll see you back here Monday morning, 9 a.m. All right, we'll stand in recess as far as the jury is concerned. And as soon as they're cleared, we will reconvene for the
Yo, that is
evidence
so cool to
determinations.
think about. Holy cow.
Ms. Clark.
Thank you, Your Honor. There was an issue raised by, I believe, Mr. Scheck and Mr. Neufeld concerning the terminology that I used in the Christopher Johnson case concerning a match. And counsel has deliberately misrepresented to this court the import of the terminology and the exchange that occurred in the course of the hearing from the Christopher Johnson case. The unfairness of that is that this court and the publicity that generates from every hearing that we have has now been completely falsified in terms of what actually transpired in court. Counsel now proffers to the court a mere few pages from a transcript seeking to establish the basis of of the misrepresentation they have made to this court. I would ask that the court refuse to accept the mere few pages they have proffered and insist on the entire transcript.
Ms. Clark, let me, forgive me for interrupting you, but I have a dislike of excerpts from transcripts as well. I've already ordered the complete court file.
Great.
Mrs. Robertson advises me that the complete transcript at my request has been delivered to the court.
Great, thank you, Your Honor. The other point I wish to make to the court in advance
Which means I get to read a whole lot more stuff.
yeah, even though, which is exactly, I know.
Julie, are you a member? I'm thinking I'm thinking of making a members only video of OJ being pro se. I I'm thinking of doing that. That would be so funny. I'm definitely going to do it. If you're Julie, it's your idea. So if you are not a member, it'll be a video for everybody. But if you're a member, I'm going to do it members only so I can be as creative as I want to be. If it's for everybody, then I got to be good. But so tell me if you're a member. It's okay either way. I'm not asking you to be a member. I'm just asking if you are a member or are not a member. Ho, ho, ho. Oh, yes. Okay, I'm going. Oh yeah, you're green. You're freaking green right in front of me. I can see that you're green. I can. Thank you, Josh, for pointing out the obvious. I'm sorry, I got so excited I forgot my head. Oh, I'm putting it while you guys are watching OJ right now. I am putting the script together. I am going to do this. It is going to be so freaking funny.
What you need to do
this weekend. Yes.
Exactly. You have volumes. I know, and let me assist the court in that regard. When you see it, the Christopher Johnson matter was a paternity match. It was a murder case without a body.
I noted that.
So when we discussed the issue of a match, the witness said, well, I can't say there's a match because I don't have a known sample from the victim. We have no body of the victim. All we have is a blood stain at a crime scene, and we're seeking to establish whether that blood could have been the blood of the son of this father, the husband of this mother or wife, the father of this child, and the sibling of this sister. I mean, so it was a paternity match we were talking about. And that's why the witness was saying, we can't say a match because we don't have something to match it to. We can only say that this blood is consistent with the being a relative of these people in this regard.
All right, Ms. Clark, I don't want to litigate that issue now.
Okay. But it is a totally separate situation from what we have here. It's not the same situation.
In reading the excerpt, enough interesting things came up, specifically the paternity issues and what the test was, that caused me to order the complete file, which I've done.
Okay. When would you like me to be prepared to address this matter, if ever?
Obviously, we'll have to breach that issue sometime when we get into the DNA testing.
Okay,
But I've got it. I'll look at it. We'll see what's there.
okay. Thank you.
All right. Thank you. All right. Now, the issue is the council you
Bye,
wanted to have a hearing
Kelly.
with regards to the videotape.
Yes, Your Honor, that's true. We can't finish today, we can come back and finish Monday morning if Your Honor wants us to.
No, I'd like to finish today.
Right.
Unless you have some other commitments, but let's finish this issue.
No commitments, but let's see what we can do.
All right.
Start to 5 minutes of our time. We're ready to proceed. I would ask, there are 4 witnesses we anticipate calling. Are they here? Or
They're
are
in a
they-
nearby waiting room.
They're where?
In a nearby waiting room, who, which that you wanted to call first?
I would like to exclude the witnesses. I call Mr. Atkins first. Atkins.
All right, and while we're waiting, during the course of the examination, Mr. Cole, I think, Mr. Shapiro, you neglected to mark one of your exhibits.
Yes, I did, Your Honor. Report, Mark, the photograph that was shown to the witness as defense 1067.
Mrs. Robertson, 1067. All right, this is the photograph by Mr. Kale circled the automobile that appears in the lower left-hand corner of the photograph.
That's correct, Your Honor.
All right, so Mark.
Thank you very much.
David Adkins, D-A-V-I-D, A-D-K-I-N-S.
Wait. David Atkins, is that? What was the Atkins diet? Was that it, David? Who did the Atkins diet? Was it David Atkins?
Good morning, Mr. Atkins.
Morning.
And what is your occupation, sir?
I'm the principal photographer for the city of Los Angeles,
And by which department are you employed?
the Los Angeles Police Department.
And are you a civilian employee of that department?
Yes, I am.
And for how long have you been employed by the Los Angeles Police Department, sir?
Almost 6 years.
I'd like to direct your attention back to the date of June 13th, which I believe was a Monday of 1994. Did you at some time on that date receive a call to come to a location on Rockingham in the Brentwood area?
Yes, I did.
And can you tell the court who called you at that time and what time did they call you?
I was called by Detective Haro, and it was probably between about 1:30 and 2:30.
Okay, Detective Haro called you?
Yes.
And what's his first name?
I don't know.
All right. And
I think it's Bill.
at,
I think it may be Bill.
all right, at that time you were, as I understand it, employed in the photo lab of the Los Angeles Police Department. And what was your title or rank therein?
I'm the officer in charge of this section. I manage the day-to-day operations of the photographic section.
All right, and that existed back in June of 1994.
That's correct.
All right. When you got this call between 1:30 and 2:30, what was the nature of the call? What were you asked to do?
I was called to respond to photograph, make a video of Mr. Simpson's home.
All right, a video of Mr. Simpson's home,
That's correct.
and you got these instructions from Mr. Haro.
That's correct.
And did Mr. Haro tell you why he wanted you to make a video of Mr. Simpson's home?
No.
All right. And based upon that call, did you do something?
Yes.
And what did you do?
I responded by trying to locate a photographer. That was a very busy day, and I had to pull somebody from our dispatcher to take him out to the scene.
And do you ultimately locate a photographer?
Would you repeat that, please?
Did you ultimately locate a photographer?
Yes, I did.
And who'd you locate?
Willie Ford.
All right. And he was one of the gentlemen who works in your particular section?
That's correct.
All right. Did you have occasion to go out to the Rockingham residence?
Yes, I did.
And did you go with someone else?
Other than Mr. Ford?
The two of you went together?
At that time?
Yes.
No.
Okay, just the two of you went to Rockingham?
That's correct.
Okay. So what time did you arrive at Rockingham, if you recall?
I don't recall, but I think it was probably somewhere around 3:30.
If that happens, it happens to oh um if you yeah try subscribing first, and then if you can't become a member, instead of trying on the YouTube app, open YouTube in a browser on your phone, not the app, and that might help.
Do you have any notes or any reports that were written contemporaneously with your observations back on June 13th, 1994?
No, I don't.
So everything you're testifying about now is from your recollection, your independent recollection?
That's correct.
You've not been able to refresh your recollection on any kind of documents, right?
Relating to what matter?
As to the time you got the call, as to the time you arrived at Rockingham?
That's correct.
You're testifying to your memory, is that right?
That's correct.
All right. So your best recollection is that you and Mr. Ford went out to Rockingham?
Shut up. That's the link. If you need a direct link to become a member, that is the link.
Together and arrived there at about what time?
Between 3 and 3:30.
All right. And when you arrived there, did you have occasion to meet with any detectives?
Yes.
And were you present when any instructions were given as to what you were to shoot at Rockingham?
Yes.
Okay. Tell us about that. Who did you talk to first of all?
When Mr. Ford and I first arrived, we were met by Detective Harper, and he explained that they wanted an overall of the exterior and interior shots. And then he handed us off to Detective Harrell.
All right. So your first conversation was with Detective Harper. And what did he say about the exterior shots he wanted you to get?
Nothing specific. He just requested they wanted general photographs of the exterior of the home.
All right. When you say photographs, did he want a video of the exterior of the home?
That's correct.
And was Mr. Ford in your presence when those instructions were given?
I'm not sure.
All right. You recall that you were there?
Yes.
And would you assume that since Mr. Ford was going to do the shooting, he was also there to hear this?
Probably. Yes, I would assume he would be there somewhere.
And then after your initial conversation with Detective Harper, you then were turned over to Detective Harrow, H-A-R-O, right?
Correct.
And where was Harrow when you first talked to him on that date?
I don't specifically recall, but I think it was outside the front door of Mr. Simpson's home.
Did you have a conversation with Detective Harrow?
Yes.
And who was present during that conversation?
Ray, thank you. Help keep the lights on. I have a script ready. I'm working on a script. It's coming out soon. I'm going to get it out as soon as possible.
To the best of my knowledge, it was just Mr. Ford and myself.
All right. And again, tell us about the conversation with Mr. Harrow.
It was a reiteration of the first instructions that they would like to get videotape of the exterior as well as the interior of the home.
All right. And any other instructions at that time?
No.
Were you told at this point why you were doing this? Why were you shooting, or were you about to videotape the Simpson home?
I don't recall if specific instructions were given to us as to why we were photographing it. My understanding as to why we were photographing it was just to document the way that the home looked at this point, in terms of what vehicles are there, what landscaping is there, and on the interior, what items are sitting where in the home.
Was it kind of a record of inventory?
Pretty much, yes.
And did you also were you also told that you wanted to make a record of everything seized by the police pursuant to a search warrant?
No.
Did you not indicate that this morning? That was one of the things that you indicated that was your impression?
No.
You did not indicate that in the conversation this morning?
No.
Did you indicate this morning that one of the purposes of your doing this video was for civil liability purposes?
That's correct.
Tell us about that.
There have been cases in the past when police officers have had an opportunity to enter a home, or had an occasion to enter a home, when claims have been made against the police department, such as things were missing, there was an expensive vase there, things of that nature, things were ruined. What we like to do is come in and document the condition of the home at that time, so that if it was ever needed again, we could show that that was there or was not there.
All right, so that's the civil liability aspect. Were you also, did you also indicate this morning that one of the purposes of your shooting the video was to help the detectives to see where items were recovered?
No, I did not.
Right, you had a conversation this morning with the gentleman to my immediate left here, Mr. Scheck and Mr. Neufeld, is that correct?
That's correct.
After you talked to them, did you have occasion to talk with some member from the district attorney staff this morning?
No.
You not talked to anybody from the DA's office?
When you say talk to them, more than say hello or,
Yes,
or
I mean,
casual
talk-
conversation?
Sorry, talk to them about your testimony at all?
No, I did not.
Okay. So do you have a recollection that you indicated this morning that you said to Scheck and Neufeld that your recordation, the video recordation was to help the detectives see in the future where items were recovered?
No, I did not.
All right. A second here. Did you ever indicate to either Messrs. Scheck or Neufeld that you wanted to make a video record? So if things weren't seized and you wanted to go back at a future time and seize them, you'd have an actual record of where these things were. Did you ever indicate that?
I may have said something along those lines.
Or what was your understanding back on June 13th with that regard?
The reason that we photographed the inside was, as I stated, mainly was for the civil liabilities issues.
Yes.
Sometimes if a detective is reviewing this videotape and notices something else, they may want to revisit that location.
All right. So provide some help for the detectives in later search warrants if there's to be one, or where things are in the residence, right?
There's a possibility that the tape could be used in that way, yes.
All right, sir. Now, you've had occasion to see that tape, have you now?
I have not seen the tape in its entirety, no.
All right. Did you see it being shown at least partially this morning?
Yes, I did.
Is that the first time you've seen it?
Yes, it is.
Since June 13th?
That's correct.
All right. And the man who actually shot the tape, as I understand it, is Mr. Willie Ford, is that correct?
That's correct.
All right. He's here this morning also?
He is.
Do you remember what kind of camera Mr. Ford was using on that date?
I'm sorry, would you repeat that
Do you
question?
remember what kind of a camera Mr. Ford was using on that date on June 13th?
Yes, it was an RCA VHS camcorder.
Camcorder? And is there a time and date on that particular camera?
Yes, there is.
All right. And prior to this date of June 13th, 1994, had you had occasion to video other crime scenes in your capacity in the photo lab at the LAPD?
Personally video myself?
Or no, been present when they've been down to your lab, had occasion to do that?
Sustained rephrase question.
No, sure. There have been other occasions when individuals who work for you in the lab of the LAPD have been asked to video crime scenes.
Yes.
Okay, how many occasions in the last year?
Fewer than 6.
And have you had occasion to go on any of those video shoots?
Yes.
And under what circumstances does the LAPD use those video shoots at crime scenes?
I would really have no knowledge as to how those are used.
All right, but fewer than 6 meaning how many? Your best estimate.
That's a pretty close estimate, fewer than 6.
But what does that mean though? Fewer, is that 1, 2, 3, 4, 5?
All right, 4.
What's your best estimate? 4?
4.
All right. And how many of those 4 had you been out on?
2.
And you don't recall any particular reason why those 4 were chosen, or there were video shoots on those 4?
We were requested to respond with video, and that's the reason, as far as my level is concerned, that we videotape those.
Would I be correct in assuming that back in June of 1994, you did not respond to every crime scene in Los Angeles to video shoot, right?
That's correct.
Okay. Did you ever, in connection with this case, ever go to the Bundy scene and do any video shooting?
I went to the Bundy location. We did not do any video.
And why didn't you do it there?
We were not requested to do so.
And so whoever was there, a detective in charge at Bundy when you got there,
Was there a detective in charge? Yes.
who was that?
The person that I spoke with was Lieutenant Rogers.
Okay, Lieutenant Rogers, and he never asked you to shoot at Bundy.
That's correct.
Why were you over there?
I was there to relieve Dieter Rokar, to have a relief for Gary Goodwin
And
out to that scene.
does Rokar work in your unit?
Yes, he does.
You supervise him?
That's correct.
And did Rokar have a video camera with him that morning when he was at
I think we're kind of far afield on this issue.
I'm almost right.
Well, we've got about 8 questions on Bundy that's irrelevant to this issue.
Right. Allow me just this.
2 more.
Thank you.
This is in the way of discovery.
Certainly,
I'm sure.
no, not exactly, Your Honor. Let me look it up. With regard to Rokar, did he have a video camera that morning?
No,
at
he
Bundy?
did not.
All right, but he did work for you at that point.
That's correct.
All right, and there was no shooting of Bundy.
No video shooting?
No video shooting of Bundy.
That's correct.
Well, I have nothing further of Mr. Atkins at this point, Your Honor.
Ms. Lewis?
Thank you, Your Honor. Just briefly, Mr. Atkins, is there a policy of the Los Angeles Police Department, which you're familiar with, which allows detectives at their choice to either have still photos taken or videotapes taken of locations where search warrants are executed?
I don't know of a specific policy, but that is my understanding.
And what is your understanding with regard to search warrants being executed and possible civil liability? Do you have one in that regard?
I need to do it again. What I always do to you, but only just for 5 minutes, maybe tops. This is like hour 9 of streaming. I need to walk away for 5 minutes. I need to get something done before it's too late. It's already 9:30 a.m. almost. I want to get it done really, really, really quick. I need to step away for 5 minutes, and then I'll be right back. And I'm just going to let this play. If they have a sidebar or if the sound goes out, I will be right back. Promise. Behave, though. Don't say anything bad in chat. Don't get me banned.
In terms of shooting video and photographs?
Yes.
I know that they're highly desirable
Why is that?
for purposes after the fact, as I explained before, to show the condition of the residents and the condition of art objects that may or may not be there.
And was that your understanding of the purpose for your presence at Rockingham on that particular occasion, was to document the location of items and what those items look like in case of future civil liability?
That's correct.
When you were at the Rockingham residence, accompanying Mr. Ford, who is the one who actually took the videos, was there a police detective with you?
At Rockingham?
Yes.
Yes.
And who was that?
That was Detective Harrow.
And are you aware that the lead investigators in this case are Detectives Van Adder and Lang?
Yes.
Were they there at the location when you were there?
At that time, for the time the video was taken?
Yes.
I'm not sure.
Do you have any recollection of seeing them or not?
At that particular time?
Yes.
No.
Did Detective Harrow, who accompanied you while the videotaping was taking place, direct you to videotape blood drops on the driveway?
No.
Did he direct you to videotape a pathway along the south portion of the residence?
No.
Did the videographer basically appear to be pointing his camera at objects, including objects of value within what may be called a trophy room at the location?
Oh,
Could you repeat the question, please?
Did the videographer appear to be pointing the video camera at objects within the location of, including those of value, such as the objects within the trophy room?
Yes.
So it was your understanding that this video was to be taken for purposes of potential civil liability in the future, is that correct?
That is correct.
oral.
That is correct.
All right, anything more? Mr. Garkin?
Did you indicate this morning to Mr. Neufeld that with regard to the 4 other crime scenes that your unit had been asked to video, that you sometimes did it where the detectives thought it would help their case? Did you indicate that?
I may have, yes.
All right. And were you asked to shoot blood drops in the foyer of the Simpson residence that day?
Not specifically, no.
Did you shoot that?
Again, I was not the cameraman, but I would say that those drops may have been in the video, but specific evidence was not to be photographed.
And you were aware, were you not, that Detectives Van Etter and Lang were the co-lead investigators on the Simpson case, weren't you?
That's correct.
You knew that day, right?
I'm not sure I knew that day.
You knew it at some time shortly around that time, isn't that correct?
That's correct.
All right. And you knew that Mr. Harrow and Mr. Harper both worked in robbery homicide, did you not?
Yes.
All right. Thank you very kindly. That's all I have this witness.
So let's, all right, Mr. Higgins, thank you very much, sir. Mr. Ford.
Yes, ma'am.
Please have a seat for witness stand. You state and spell your first and last names for the record.
My name is Willie Ford Jr.,
Mr. Ford, what is your occupation, sir?
photographer for the city of Los Angeles.
And for how long have you been so employed?
13 years.
I'd like to direct your attention back to the date of June 13th, 1994. You were employed by the Los Angeles Police Department at that time as a photographer?
Yes, sir.
Did you receive a call to go to some location on that date, the afternoon hours of that date?
Yes, sir.
What time do you receive a call, sir, on that particular date?
I don't know the exact call, but it was afternoon.
All right, did you
sometime
tell,
in the afternoon?
we had occasion to speak with you earlier this morning, is that correct?
Yes, sir.
And at that time, did you indicate to us that you believed you received a call somewhere around 1:30?
Yes, I did.
And after you received this call, were you asked to go to some location?
Yes, sir.
And where was that?
On Rockingham.
Okay, and that's in Brentwood area?
Yes, sir.
And did you go to the Brentwood area accompanied by some individual?
Yes, sir.
Who was that?
That was my boss, David Atkins.
It's the man who just preceded you, understand?
Yes, sir.
All right. And did you have some instructions when going to the Brentwood residence on Rockingham?
Yes, sir.
What were your instructions, sir?
To photograph Mr. Simpson's property, any and everything from his cars, lawn furniture to pictures on the wall.
You were to photograph everything you saw, is that correct?
Everything.
And by the way, who gave you those instructions?
I don't know the exact names.
Well,
the detectives in charge of the scene.
okay. Detectives in charge of the scene.
Yes.
Would the name Detective Harper
Yes.
be one of those individuals?
Yes, sir.
Is that an African-American officer?
I don't know.
All right. What about Detective Harrow, H-A-R-O? Is he one of the ones?
Yes, sir.
Who talked to you? All right. And your instructions were that you were to shoot any and everything on the Simpson residence. Is that
Yes,
right?
sir.
Is that right?
Yes, sir.
And what time did you arrive at the Simpson residence? Again, your best recollection.
Approximately about 2 o'clock, I think, 2 or 3 o'clock.
Okay. Somewhere about 2 o'clock or thereafter. And when you arrived there, did you follow these instructions and start to shoot the video?
Yes, sir.
And how long were you there? If you got there around 2 o'clock, how long were you at the residence?
I would say approximately an hour and a half.
So if you got there at 2, you'd be finished somewhere around 3:30 or thereabouts?
Yes, sir.
And were you using an RCA camcorder of some kind?
Yes, sir.
And the tape that you were shooting, how long could you shoot without changing the tape?
I didn't change tapes at all.
So the video that we're talking about here was shot all on one tape.
Yes, sir.
Is that correct? And you've had occasion now to see that tape since you shot it. How much tape is there?
Approximately 20 to 30 minutes
All
tape.
right. So you got this 20, 30 minutes of tape over a period of about an hour and a half. Is that correct?
Yes, sir.
All right. Now, did you start off by shooting outside?
Yes, sir.
And what'd you shoot outside?
Started with the Bronco, panned over to the driveway that's on the Rockingham side,
Thank you.
and proceeded to photograph the cars and the yard
front of the house,
What about the house?
front of the house.
All right. Did you go on the other side, the south side of the house?
Yes, sir.
Did you-
No, not the south side. It would be the north side.
On the north side of the house?
Facing the house would be the north side.
Did Detective Harper tell you to shoot both the north and south and each side of the house?
No, sir.
So you shot the north side?
Jammers. Jammers are very cheap.
Yes, sir.
You shoot any other side?
No, because from my point of view, it was just the house butted up against the fence.
You didn't go down the south side of the
No,
residence?
sir.
All right. Nobody, no one asked you to do that?
No.
All right. And how long of this 20 minutes did you spend shooting outside?
I would estimate about 20 minutes.
No. How long? I thought that the entire thing was 20 to 30 minutes. So 20 minutes of that was outside?
Yes, sir.
Okay.
This is not continuous running.
Okay. And you would shoot, cut off, go to some other location. Is that what? Is that right?
Roger.
Okay, sir. Now, while you were shooting outside, were you being directed what to shoot by one of these detectives who were there?
In the beginning, I was directed to shoot. And then I was basically left on my own until I finished completing all the outside. And then I would come inside and get further instructions.
Can you give us the name of the officer who was directing you at the beginning?
It was the African-American officer. I don't know which name he is.
Let's call him Harper.
Harper? Okay.
Yes. All right. And so he told you what to shoot, and then he let you go on your own. Is that right?
Right.
Was Mr. Atkins anywhere near there at that point?
At some points.
Now, with regard to prior shoots, had you had occasion to ever shoot any of the crime scene before this date of June 13th?
Yes, sir.
When was that in relation to June 13th?
I would say approximately 3 months earlier.
And was that a training session for you?
Yes, sir.
And you've been trained at the earlier situation, is that correct?
Yes, sir.
This is the first time you did it on your own?
This is the first time that it was done by the request of the detective.
Okay, on your own.
Yes, sir.
All right. Now, after you concluded shooting the exterior, you had occasion to go inside, is that correct?
Yes, sir.
And once inside, were you directed what to shoot by a particular detective?
Yes, sir.
And was that Harper or was that another detective?
Another detective.
Is the name Haro, H-A-R-O?
I think so.
Similar? And what did Mr. Haro or Detective Haro tell you with regard to what you should shoot?
To photograph everything inside of the house, including pictures on the wall.
Did you try to do that?
Yes, sir.
And that took up the balance of what we now see on the tape. Is that correct?
Yes, sir.
And you would shoot and then cut off and move to other locations. Is that
Yes,
correct?
sir.
But did you try to recover? Did you try to shoot everything that appeared out in the open?
Yes.
So you'd have a complete record?
Yes.
Okay. And what was your understanding as to why you were doing this?
Just in case there were some items of Mr. Simpson's that was very valuable missing, LAPD wouldn't be accused of taking anything.
You wanted to make a complete record. Is that correct?
Yes, sir.
Do you know whether or not the officers there, the detectives there, were still searching at the time you were doing the shooting?
I'm aware that they were doing some type of ongoing investigation. I wasn't really paying attention.
All right. You don't know if you didn't see anybody searching through doors while you were there,
No.
did you? All right. So you did your shoot. And by the way, I want to very briefly, Your Honor, if I can, ask to show Mr. Ford a portion of the video at the appropriate time.
Yes.
Thank you. Mr. Ford, let me skip ahead for a moment. After you finished and concluded this video, what'd you do with it next?
We took it back to the photo lab at Parker Center.
And when you say we, you mean you and Mr. Atkins?
Yes, sir.
And what'd you do with it that date on June 13th?
Mr. Atkins told me he locked it up in the confidential file in his office.
All right. Did you have occasion to give that video tape to someone on June 14th, 1990?
Yes.
And who was that?
I think it was Detective Harrell.
All right. Was it Haro or Looper?
I think it was Harrell.
I think it was Haro, the man who gave you the instructions the day before?
Yes.
All right. And where'd you give it to him? Where'd you give him the tape?
Down on the 3rd floor, Parker Center, robbery homicide.
All right. Was that the last time you saw that tape?
Yes, sir.
And between June 14th, 1994 and today, Had you ever had physical possession of that tape from that time?
No, sir.
You gave him one tape, one copy?
One copy.
All right, now, with regard to the things that you were to shoot inside the residence, I'd like to just show two brief things and ask him a question, Your Honor, if I might. You see the video there?
Yes, sir.
And this is being shot by you, is that correct?
Yes, sir.
By the way, there was, well, I'll get to a particular point and ask you a question. Now, right there, you see that? Did you shoot that glove there by a picture of a young lady there?
Yes, sir.
Was that glove placed there before you got there?
I don't know if it was placed. It was there.
All right, can you back it up?
Your Honor, for reference purposes, could we note that the time displayed on the video is 2:50 when the blood is taken?
Yes.
It says 2:50 p.m., 6/13/94, and we stop it there. That is the way a glove appeared there, but the photograph of the young lady at the time you shot it. Is that correct?
Yes, sir.
Did anybody tell you to shoot that?
No, sir.
All right, that was just out there in that condition.
Yes, sir.
Now, with regard to
Oh,
this RCA camera that you had,
Okay. See this monitor right here? Back at the beginning, I don't know if it was just the preliminary hearing or if it was the beginning of the trial. I can't remember. I can't remember when it was. It doesn't matter. Back at the beginning of my videos, this word Sony, someone had colored it black. So it stood out. It said Sony. It says Sony now, but someone had colored it black. And I remember someone in chat one day said that somebody got into huge trouble because they made this Sony stand out. I think someone from Sony did it. I don't know how. No idea. But someone got in big trouble for messing with that monitor, and now it's a different monitor.
it had a viewfinder in which you could look and see the time that you were actually shooting. Isn't that correct?
Yes, sir.
And the date?
Exactly.
So you could look and you see there was 2:50 p.m. on June 13th. Is that right?
Yes.
All right. All right, we're going to fast forward.
Julie, my first computer was a leading edge. Are you kidding me? That's awesome. I had the same computer you did. My mother got it from Avon. Like she was the sales rep of the month or whatever, and she got this leading edge computer from Avon. And we were the first people in my whole neighborhood to have a computer. And I had so much fun on it. And that's why that's why I got my master's degree in computer science, because I was back there with my leading edge and my little floppy disks.
The glove.
Avon
was the detective
calling.
with you at that point?
He might have been. I don't know.
Do you recall him saying anything to you as you were shooting that glove?
No.
You don't recall him saying keying on the glove at all? You don't recall?
No.
All right. We'll find the setup portion in just a second. All right. Now, this, you described for us that this tape that you shot was given to somebody at robbery homicide on the third floor of the LAPD on June 14th. Is that right?
Yes.
And then when's the first time you saw this videotape?
This morning.
And where'd you see it?
At robbery homicide.
Before you came over to court today?
Yes, sir.
All right. And who else was present while you were looking at the videotape?
I think Detective Harrell and my OIC David Atkins, and I don't recall anybody else.
And that was all this morning at what time?
Approximately 7:30, 8 o'clock.
All right. You also shot, you went upstairs in the interior of the residence and you shot photographs or a video, the bedroom of Mr. Simpson. Is that correct?
Yes, sir.
And in doing that, did you make an effort to shoot everything that was out there in and around that bedroom area?
Yes, sir.
You shot what was on the bed, right?
Yes.
Shot what was on the floor, if anything?
Yes.
All right. And so you tried to give a complete record again of shooting any and everything. Is that correct?
Yes, sir.
All right. So I want to show you some video if I can. All right. This is the bedroom. Is that correct? Do you recall that?
Yes.
As best you can recall, you're shooting at 3:13 p.m. on June 13th in the bedroom, right?
I understand the time is off about an hour.
I'm asking you what your understanding was at that time.
Uh,
3:13 p.m.
I paid no attention to the time. I was too busy concentrating on getting the images.
But you see the time, 3:13 p.m.?
Oh, yes, sir.
You see that time? Now you shot what was on the bed there, is that correct?
Yes.
These things were out in the fashion that we see them there in that photograph there at
Yes, sir.
3:14 p.m. You went inside his closet and shot there also, right?
Yes, sir.
Shoot any luggage in that particular closet, do you recall?
In viewing the tape this morning, I think I did see some luggage.
Those weapons there, were they taken out from, were they in that condition out there like that when you got there?
Everything I videotaped was out already.
You know who moved it out there?
No, sir.
Was Haro still with you at this point, or one of the detectives with you at this point?
No, I'm by myself at this point.
You're on your own?
Yes, sir.
Shooting any and everything?
Yes, sir.
Like I saw you in the mirror there. You see yourself?
I missed that one.
Back up just a moment. With regard to the in the bedroom area, did you see a rug of some kind in the bedroom area before the fireplace there that day?
Okay, you're talking about the fireplace to the right there?
No, I'll point it out to you, sir. Go for it.
Excuse me, I don't have any further questioning along these lines. The court, Mr. Cochran asked leave of the court to ask a couple of questions about the videotape. This appears to be a fishing expedition by Mr. Cochran with this witness on the stand. There's no need to take up this court's valuable time with this type of questioning.
Oral.
I'm gonna stop there. Did you see, oh boy. Back up frame or two. 313. You see that carpet? See that carpet there, the 3:13 p.m., kind of at the foot of the bed? Can you see
Yes,
that?
sir. Mhm.
You take a photograph of that carpet that day?
Just what you see there.
And so just what we see there is what you saw, is that correct?
Yes, sir.
You didn't see anything unusual at that point, did you?
No, sir.
You tried to capture everything that was out there that was anything, right?
Exactly.
So what we see here with regard to the carpet, we'll back it up, let you see it, is what you saw that day, is that right?
Yes, sir.
All right, back it up and then move forward.
Mr. Cochran, in presenting this to me, bear in mind, I've seen this thing completely end to end 5 times now.
5 times now here? Okay, well, I will bear that in mind and move right ahead. Just want to conclude this point.
All right.
Well, your quick study. So, okay, move forward now, move forward. So you pick up everything that you see there on the carpet at that time, is that right, sir?
Yes, sir.
All right. You tried to show everything, all right? Is that right?
Yes, sir.
thank you, Mr. Harris. Now, you started to say something, and with regard to the time, when was the first time anyone told you that the time of the tape might be off? Was that today?
No, that was, I think about 2 days ago.
And who told you that?
My OIC, David Atkins.
David Atkins? And you hadn't seen the tape at that point, had you?
No, sir.
So that we're clear, however, you got the call about 1:30, you got out there sometime around 2 o'clock, is that right?
No.
Sustained.
You got out there at what time?
According to the sign-in log, is around a little bit after 3.
Well, did you say earlier you got there between 2 and 3, sir?
You asked me what time that I thought that I got there.
Yes.
That's the time I thought I got there.
Between 2 and 3, right?
Yeah.
All right, and then you then proceeded to shoot for an hour and a half at most, is that right?
Yes, sir.
All right. And so that would comport with the times you saw in that video. Is that correct? That you were shooting sometime after 3 o'clock? Isn't that correct?
Yes.
Overall.
Comports with the times you saw, right?
Yes.
You never tried to change the time that particular day, did you?
No, sir.
All right. Thank you very kindly. I have nothing further this witness. Your Honor.
Ms. Lutz?
Just briefly, Your Honor, Mr. Ford, when was the first time that anyone asked you about what was recorded or why you recorded that videotape on that occasion?
About 2 days ago.
So it's been some 8 months, 8.5 months now since you'd had occasion to even think about having taken that videotape back last June?
Yes, ma'am.
And your estimation of the time that you took,
Have it quiet in the courtroom, please.
your estimation of the time that you arrived and that you took particular things shown on the videotape is just based on your best recollection now, 8.5 months later, is that correct?
Yes, ma'am.
And you indicated you did not pay attention to the time on the camera itself, is that right?
Exactly.
So you really can't say with certainty any time that you took any particular aspect shown on that videotape, can you?
No.
Nothing further.
This, with regard to the time aspect, sir, you were aware that this was an important video to document what was going on, isn't that correct?
Yes.
And you were doing the best you could, is that correct?
Yes.
You shoot any and everything, right?
Yes.
And if you had seen or were aware the time was off, you could have changed that or corrected it, isn't that correct? Isn't that correct?
I would say yes if it was of some concern, yes.
Yes. All right. Thank you very kindly. Detective Looper, Your Honor.
Ms. Lewis, anything more?
May I have just a couple of questions outside the scope of my initial cross, just briefly?
Briefly.
Did any detective or anyone else direct you to take photographs or videotapes, I should say, of blood drops in the driveway at Rockingham?
No.
Did anyone ask you to video the pathway that runs between where the house butts up against the fence on the
No.
south side? Did anyone indicate to you that this was going to be used by the district attorneys in the case?
No.
And was your understanding that this was taken to document the valuable items that you saw throughout the house?
It's cross-examination.
Well,
I'll allow the question.
And was it your understanding that your purpose in taking this videotape was to document the valuable items that you saw throughout the house, including the Heisman Trophy and other items of value, so that the Los Angeles Police Department would have that on record as having existed then in case of a later lawsuit? Was that your
Yes.
understanding?
Testify.
Was that your understanding, sir?
Yes.
Thank you.
And when you took that picture of that glove there, you thought that was a valuable object, did you?
Counsel, I saw what was on the
Okay.
table there.
All right, well, all right, very well. Then.
Looked like a Tiffany-style lamp and a few
Well, there
other
was
things.
also, he zoomed in on the glove, however.
Just for the record, did you notice that there were valuable items on that table, like a lamp or so forth, in
Yes.
addition to the
Ms.
glove?
Lewis, you should also bear in mind that I've seen this 5 times.
Just for the record, Your Honor, thank you.
One last question, Your Honor. Did you shoot some reported blood drops in the foyer area of the residence?
Yes.
Somebody told you to do that?
No.
You just did it on your own?
Yes.
Again, shooting everything you saw, right?
Yes.
Okay. And you, with regard to the purpose, your purpose for being there, you've told us your purpose was to shoot any and everything at the direction of the detectives who told you to do this, right?
Yes.
All right. Thank you, sir. All right.
All
Looper,
right,
Your Honor.
Detective Looper, thank you very much.
Okay.
solemnly swear that the testimony you may give in the cause now pending before this court should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat. The witness stand and state and spell your first and last name for the record.
Yes, ma'am. My name is Adalberto Luper. First name is spelled Adalberto. Last name is Luper.
Good morning, good afternoon now, Detective Luper.
Good afternoon, sir.
You are one of the investigating officers assigned to this case, are you not?
Oh, well. Yes, sir.
She's getting practice. And then in that connection, back in June, on or about June 13th, 1994, were you one of the officers or detectives from robbery homicide assigned to the Simpson case?
Yes, sir.
Did you at some point on or about June 14th receive a videotape that was shot of the Rockingham residence, sir?
Yes, I did.
What time on the 14th did you receive such a tape?
It was in the morning sometime. I don't recall the specific time.
Your Honor, at some point I should mark this tape. It's over there now, so we'll reserve a number so I don't forget to mark it. And this defendant's
1068.
defendant's 1068. So you received, and you've seen the tape this morning, have you not?
Yes, sir.
Okay, it's about a 20, 30-minute tape. The defendant's 1068. You received.
Oh, proceed.
You received this tape sometime on the 14th in the early morning hours.
That's correct. It was in the morning. Yes, sir.
Do you remember about what time it was?
They have to be anywhere between 8 and 10, somewhere in that.
And from whom did you receive this tape?
I received it from, I believe it was Detective Harrell.
From Harrell? Yeah. And where were you when you received the tape from Harrell?
I was at Parker Center, room 321, at my desk.
And when you received it in room 321 at Parker Center on June 14th, in the early morning hours or between 8 and 10, what'd you do with the tape at that point?
I went upstairs to the electronics section and asked to be able to use their VCR and monitor to view the tape.
And did you view the tape at that point?
Yes, sir, I did.
So you saw it on the 14th?
Yes, sir.
It's the same tape we now have here today?
That's correct, yes, sir.
And did you view it by yourself or with someone else?
By myself.
All right. After you viewed the tape, what'd you do with it at that point?
I returned down to my office because I was charged with having to write the employee report of the search warrant. And I was informed that it wasn't necessary because the captain had been there and the employee report would have been submitted to him.
Is that Captain Garland we're talking about?
Yes, sir.
And so you did not write an employee report about this item?
That's correct, sir. I did not.
All right. You then you had possession of the tape, Defendant's 1068. You had seen it by now. Did you write any reports at all at that point?
No, sir.
You then did something with that tape?
Yes, sir.
And what was that?
I put it in my desk drawer.
Okay. Now, at this point, this was your regular desk drawer?
Yes, sir.
Okay. Now, did you ever take that tape up or put it in the so-called Simpson War Room at Parker Center?
Yes, sir.
When was that?
That was probably 3-4 months later.
All right. So at first you put it in your desk. Is that correct?
Yes, sir.
And about how long would you say it stayed in your desk?
About 3 or 4 months.
And then you had occasion, there was a Simpson War Room developed, and then that's also in Parker Center?
Yes, sir.
And then you had occasion to move it from your desk?
Yes, sir.
When was that approximately?
It would have been around the same time, 3 or 4 months after the video was taken, along with several books that I had.
So it would be July, well, strike that, would be about September, October?
Yeah, roughly September, October, yes, sir.
Again, do you have any reports about the time it was moved from your desk to the war room area?
No, sir.
All right. But it remained in police custody at that point also?
Yes, sir. It was locked up in a file cabinet.
And by that time, when it was moved to the location in the war room, the preliminary hearing had taken place, is that correct?
Yes, sir.
And by that time, if you recall, had we started picking the jury in this case?
I really don't know, sir.
All right. If it was in October, you were aware of the proceedings that took place here?
I'm aware of the proceedings, yes, sir. But as to the chronology, no, sir.
All right. So you don't know whether it was during pretrial or we started picking a jury at that point?
That's correct, sir.
But you can tell us within 3 or 4 months of the time you first received it on June 14th, after it was in your desk, it was then moved to a file cabinet in the war room at Parker Center. Is that
That's
correct?
correct, yes, sir.
Now, it's inside the Simpson garage there at Rockingham?
Or will,
No, sir, it had nothing to do with any testimony.
You just,
Nope. Tomorrow. Tomorrow we'll see what he just tomorrow. Let's see. This is this is only a 6-minute video. Let's just go. Let's just do it.
remember that you had this tape at some point?
It was brought to my attention that it was possible that I was going to testify to the execution of the search warrant.
All right.
And during my research of that, photographs, et cetera, I remembered that we did have a videotape.
Now, with regard to this video, there were a number of officers out there on the date that video was shot, right? Correct?
There were several patrol officers. I believe there was maybe 7 detectives, 4 from robbery homicide, 3 from West LA. And I believe Mr. Fung and Ms. Mazzola, and I think the print people had already left.
Just so we're clear, you were there, right?
Yes, sir.
All right. And was it your understanding that this video was shot during the execution of the search warrant, or had all items been recovered by that time?
All the items within the residence had been recovered at that time. I knew that there was some presumptive tests that we were still doing, but as far as I was concerned, all the evidence had been recovered. Yes, sir.
All been recovered except for maybe some presumptive tests, right?
That's correct. Yes, sir.
All right. And just quickly for us, can you give us the names of the detectives from robbery homicide who were present during the taking of this shooting of this video?
It would have been Detective Haro, Haro, Detective Harper, Harp.
Tomorrow there'll be French fries though.
My
Yep.
partner, Detective Lafall, Lefall, myself, and possibly Detective Roberts. And that's the only ones that come to mind right now, sir.
All right. And you mentioned something from West LA. Anybody from West LA you recall?
But that would have been Detective Roberts from West LA. I would have to check the crime scene log to be sure.
All right. Now, at some point, you were told that you might have to testify in connection with the search warrant.
That's right.
In this particular case here.
Yes, sir.
You didn't testify in any of the pretrial motions, did you?
No, sir.
Like I go through my day like, oh man, I wish Nan could see that. Or oh, CJ should taste this. Or Donald would love this. That's how I go through my day.
All right. And when were you told that, and by whom?
I was told that the last week of February of this year, and I believe it was Detective Van Adder who informed me of that.
So in February, Van Adder told you might have to testify in connection with the search warrant.
That's correct, yes, sir.
And then you started looking at photographs and videos, and you discovered this tape, right?
Looking at photos, yes, no video, but I realized we had a video at that time, yes.
All right. And when did you bring the fact to the attention of the district attorney's office that you had this video?
That was either March 22nd or March 23rd of this year, sir.
So even though you knew you discovered it yourself back in February?
No, I believe it was probably a week or 2 after that that I discovered it.
So maybe the first part of March?
Yeah, within the first 2 weeks of March, yes, sir.
All right. And you told the district attorney's office about this, or someone represented on or about March 22nd?
That's correct, yes, sir.
Who was told?
Detective Tom Lang was told, at which time we made a notification to the city attorney's office, and then it was then subsequently turned over to the district attorney's office.
Who in the city attorney's office did you talk to?
I don't recall the name, sir. I didn't make the call.
That would have been in the first week or so of March?
No, that would have been on March 22nd or the 23rd.
But when you first discovered it during the first week of March, who in the robbery homicide division did you talk to about this?
Nobody.
You didn't tell anybody at first?
No.
All right. And when's the first time you told somebody in robbery homicide?
It was either, it had to either be March 22nd or the 23rd because that was the first time that it was brought up by myself.
And who'd you tell at that point?
Detective Lang.
So any particular reason you didn't tell anybody between the time you discovered the first week of March and March 22nd, 23rd?
No particular reason other than that I didn't at that time feel that it was something that they needed to know because of the reasons it was being held initially.
I see. And what was your understanding for why this tape was shot originally?
It was shot strictly for administrative purposes to record the valuable items in Mr. Simpson's residence and to prevent any civil liability that might arise in the future.
Was there a city attorney on the premises on the date it was shot?
No, sir.
And when you saw that tape, you saw, however, strike that. Were you aware that the man who shot the tape had received instructions to shoot every and anything inside the residence and most of the exterior? Were you aware of that?
My understanding of the instructions were that he was to film the valuables in the residence and to do a cursory filming of the exterior. Yes, sir.
Did you, when watching the tape, did you see the glove on the table that was zoomed in
yes,
on?
sir.
You didn't consider that one of the valuables, did you?
No.
All right, Mr. Cochran, we're going to need to break here.
Can we approach this a second? Well, we can approach.
Well, what I anticipate doing at this point, breaking here, I have a 1:30 calendar. I have a white collar sentencing hearing with 4 defendants at 1:30. So I anticipate recessing this now and reconvening at 8:30 on Monday.
All right, that's
All right. Detective Looper, I'm going to order you to return Monday morning, 8:30. Don't discuss your
I don't share in your honor's faith in making that assumption.
Sorry, Ms. Lewis, but
Yeah,
bye.
Detective.
We've been streaming for 5 hours, guys. We need to stop. It doesn't feel like it, does it? It feels like I just started, but it's been 5 hours. Oh, man. Josh, you have an amazing day. You do that. I will see you all again probably sooner than you think. Have a great day, guys. Bye.